Thank you, sir. Lordship, I'd like to mention item number 20. I've also taken the consent from the opposite side, Madam. An IA has come for the petition, a writ petition. An IA has been filed by one party, my lord, for deletion of their name. I need to file an objection, madam. Item number 20.
On deletion.
On deletion, yes, on deletion, madam. So I need to file an objection to that. So kindly grant me 2 weeks time, madam. Item 20.
Okay, after 2 weeks.
After 3 weeks, madam.
Okay. List after 3 weeks. Both sides are represented. List after 3 weeks so as to enable the counsel for the opposite party to file
For a
objection.
yes, all right.
Please, Your Lordship, I beg to mention petition number 11 on behalf of Anula LKR. Your Lordship, I have received the additional affidavit, so kindly grant 3 weeks to go through and if possible to file an affidavit to reply
Additional affidavit has been filed
by the state.
by the state.
Affidavit in opposition.
Affidavit in opposition.
Yes.
That's why. Okay. Both sides are represented. On the prayer made by learned counsel for the petitioner, list after 2 weeks so as to enable her to obtain instructions and to take appropriate steps.
Worship, I'd like to mention item 14 on behalf of S. Chang, government applicant. Wait for 3 weeks, Your Lordship, to file affidavit in opposition.
3 weeks.
Yes, Your Lordship.
Okay, both sides are
If I
represented.
may, Lordship. Lordship, this matter is pertinent to appointment on compassionate ground, Lordship.
Appointment of?
Compassionate ground, Lordship.
Okay.
And the main object under the compassionate scheme is to give speedy relief to the deceased family, Lordship. So, last chance may be given, Lordship.
Both sides are represented. On the prayer made by learned government advocate, the matter stands adjourned today. Next, as the matter relates to appointment on compassionate ground, no further adjournment shall be granted on the next date of listing.
Last one.
Lordship, I have a similar prayer for item 15.
Okay. This is also compassionate appointment? No.
This I'm on behalf of S. Chang, so I'm not aware.
No, this is not compassionate appointment. What is the subject matter?
May I please, Your Lordship? This instant petition relates to non-regularization of the petitioner.
Okay. What says the representative on the matter, on the prayer made by learned government advocate, placed after 3 weeks.
Your Lordship.
And for the petitioner is
25.
25. Also, I have some difficulties today, Lordship. This matter may be taken up on Thursday, Lordship.
Thursday.
Lordship.
May I please, my Lord, Your Lordship, on Thursday, Your Lordship, 2 of my matters is already fixed in court number 2. If it can be taken up on Friday, my Lord.
Friday will be difficult because I'll have to leave early. That's the. We'll see, we can make an adjustment
Lord,
on that day,
Lord,
Thursday. Both sides are represented. On the prayer made by learned counsel for the petitioner, list on Thursday is. Yeah. Thursday. Next para, the learned government advocate submits that he already has 2 matters listed on the said date, and therefore he prays that some accommodation may be made on that day.
Lordship.
Okay. List on so and so.
Obliged, madam.
Please, Your Lordship, I beg to mention item 12. For the respondent. It has already been vetted, but I'm yet to receive a copy, so if it may be listed after 2 weeks,
2 weeks.
yes.
Okay. Both sides are represented. The prayer made by Learned Counsel for the respondent, list after 2 weeks.
Lordship, interim and extended lordship. There's an interim lordship.
Okay, interim order passed either stands extended till the next date of listing.
Right.
Thank you, so Lordship. Lordship, I beg to mention item number 27, hearing item number 27. Lordship, if this matter may be discussed after 3 weeks.
Okay, you've taken consent of the other side? You've taken consent of the other side?
Lordship, actually, the counsel for the central government, respondent number 2, has actually requested me that he is yet to receive his instruction, and also that he's not able to come today. So he has requested me if
Okay,
I can accommodate him.
okay, both sides are represented on the prayer made by Learned Counsel for the petitioner, list after 2 weeks,
3 weeks. 3 weeks.
3 weeks.
Obliged, Lord.
May I please, Your Lordship, I beg to mention hearing item number 24. Here, we are yet to receive instruction. If our period sometime may be granted.
You're for petitioner.
Lordship,
It's a 2020 matter.
Lordship, we are going to file affidavit regarding the inquiry report in the opposition filed by the state correspondent. If I pray that a week's time may be granted.
Just wait, it's just, give us item 24. What inquiry report?
Your Lordship, there was an inquiry, Your Lordship, before the filing of this case. Actually, this petition is a second round of litigation, Your Lordship. On the first round of litigation, Your Lordship, there was a direction to dispose of the representation. So to dispose of the representation, the department, they actually set up a committee to inquire into the matter. So after inquiring into the matter, we found that they have stopped attending to the duties from 2006. And therefore, the government gave a reply that their case cannot be considered for regularization as they, and even for the salary, because they have actually stopped attending duties from 2006. So after that, they are coming before this court challenging that representation, as well as they're praying for regularization and backward salary.
We can't allow your prayer. In your prayer, your writ petition is only regarding termination. That inquiry is not a subject matter of challenge here.
Lordship, it's for reinstatement and regularization, and they are saying that we have stopped.
No, whatever, but you see, this your prayer is only to quash that termination order. If you have consented to have inquiry during the pendency of the writ petition, then merely by allowing you to file an affidavit, we can't extend the contours of the prayer made in the writ petition.
Lordship, I pray that this matter may be listed after a week, since the leading.
I'll just adjourn it. I'll not make any observation. Both sides are represented. The prayer made by Learned Counsel for the petitioner, list after 2 weeks.
Please, my lord. Lordship, I beg to mention item number 16 and 17. Can you grant me 3 weeks time to obtain necessary instructions, Lordship?
Item
16 and 17, these are analogous.
you're for the government.
Lordship.
This is which department?
Lottery, Lordship. Lottery and finance.
Both sides are represented. The government advocate summarizes that he is yet to receive instructions from the finance department and the lottery department. The learned government advocate shall send a downloaded copy of this order to the authorities of both the departments to bring it to their notice that if in the event the instructions are not provided, the authorities of both the department shall be personally present in court along with all instructions to assist the learned government advocate to respond to the court queries. List after 2 weeks.
3 weeks, Your Lordship.
3 weeks. You send this order to them.
Lordship, I have received only service.
No, whatever we, but send this order to them.
Lordship, the service copies I've received only on 27/8. It's not even it's not even 2 weeks yet. This is the first time coming and service copies they sent.
Okay, you did not receive, you received on
7.
27/8.
Yes. So
Then don't say that. 2 weeks, 3 weeks, list after 3 weeks. Okay.
Lordship,
Wait, Your Lordship, I'd like to mention hearing item 26.
Item?
26, hearing item 26. On behalf of Masila and Nagamar, Lordship, pending this matter be fixed on Thursday. Since Masila has some personal participate.
Okay, Thursday. So the president of the prayer made by the council for the petitioner, list on so and so. Okay.
Please, Your Lordship, I may kindly be allowed to mention item 18, Your Lordship. In this matter, Your Lordship, the state is yet to receive instructions and I'm yet to file counter, Your Lordship. So this may kindly be listed after 3 weeks.
Why, if the government is not interested to file an affidavit, you want an adjournment?
In this case also, I received the service copy after 10 days. So I had.
Oh,
to
you are
bring
for the government?
Yes, Your Lordship. I had to send the service, the notice very late, Your Lordship. That's why I'm yet to receive instructions.
Okay, same order. On the prayer made by the government, good list after 2 weeks. 3 weeks.
3 weeks, Your Lordship.
Okay.
Your Lordship, item 19 also same prayer, Lordship. 19.
Okay.
Much obliged, Lordship.
For admission, item number 1.
Yes.
On behalf of my colleague, Your Lordship, kindly grant 3 weeks time to file counter, Your Lordship.
No, last time you said the order says that you wanted 6 weeks time to file status report in form of an affidavit. As you said that the matter is being processed. Now, what is the status of the processing of the file of the petitioner?
If I may, Your Lordship, this matter be listed after some time, Your Lordship, she's engaged in court too, Your Lordship. My colleague,
Okay.
much obliged.
After some time.
For admission, item numbers 2 to 6.
With this, my lord.
Yes.
My lord, I have received the affidavit in opposition filed by the state respondents this morning, Lordship. Lordship, I may be allowed 2 weeks' time to file my affidavit in reply. I've received just this morning, Lordship.
Okay. By the respondents,
Yes, Lordship. On behalf of all the respondents, Lordship.
both sides are represented. The land counsel for the petitioner prays for how much
2
time?
weeks.
2 weeks time to go to the affidavit in opposition filed by the respondents today. And to do the needful. Next one, prayer is around this is the matter after 2 weeks.
For admission, item number 7.
No, please, Your Lordship.
Yes.
Lordship, hearings are complete, and in fact, this was fixed for final disposal, my lord. If Your Lordship, this is,
Yes, make your submissions.
Lordship, going to call the government. Government is on the other side, only the state. Lordship.
What is your, you are in UDA?
I was a UDA man. Lordship, Lordship is aware. Lordship
No,
is
but
aware.
then you would be guilty of overstay.
I'm-
As a UDA, it was your responsibility to inform yourself about the date when you were to retire.
Lordship, all along, my date of appointment was taken as 1/4/1989. And they have notified even in 2018 that I'm going to retire only in 2024. Because, my lord, I was initially appointed on a substitute basis on 2/1/1987. And thereafter, I was regularized in 1/4/89. And all along, my lord, in the service book, as well as in the seniority list, my date of appointment has been taken by the department as 1/4/89. And therefore, I complete 35 years of service only in the year 2024. In the seniority list of 2019, my lord, there also my date of retirement is shown as 31/3/2024, and my date of appointment as 1/4/89. That is totally in conformity with the service records, my lord. And only after making me work for 16 months, they say, no, you ought to have retired on, your date will be counted from the date on which you were appointed as substitute basis, and therefore you should have retired in.
No, but you are not getting a fixed pay, you were getting skill pay.
I'm getting scale pay. So my lord,
Even when you were appointed
Yes, my
initially,
lord.
then also you
Yes.
got a skill
so
pay.
therefore, my lord, this overstay is not due to my wrong representation, misrepresentation, or any wrong on my part, but the department themselves took the decision only in June 2023 that I should have retired in January 2022. Therefore, my lord, if
Show your that service book where it's the
Yes,
entry
yes.
about your.
lordship, may I just take your lordship to the relevant documents, my lord, from page
The-
70, Service-
entry in the service book would be good enough.
lordship.
Entry in the service book would be good enough.
Lordship, may I kindly see at page 22?
22.
Yes, his handwritten. He has been appointed, my lord. He has been appointed temporarily to act as LDA. Initially, I was appointed as LDA in the scale pay of such and such, by order number such and such, dated 29/3/89. Lordship, may that order 29/3/89 is annexure to page 19.
19.
19. May I kindly see here, my lord, clearly mentioned. Clearly mentioned, my lord, here. Page 19. Page 19, order dated 29/3/1989. My lord, may I read this? The service of Mua Imsu, substitute LDA of the Office of the District Sport Officer, Mokchung hereby regularized with effect from 1/4/89. So my date of appointment is 1/4/89, and therefore, my lord, I was promoted, and my kindly see the seniority list at annexure 5, page 27. Lord.
Just a moment.
Page 27, my lord.
Just a moment. The government who is appearing? Do you dispute this factual position that he was appointed on 89 and then
Your Lord-
service book contains 1989?
Yes, yes, that was a wrong entry, Your Lordship. Your Lordship, OM. We filed a detailed affidavit, Your Lordship, and the office memorandum. Office memorandum,
4th March 22.
yes, yes.
Come to that 4th
Lordship.
March, come to that 4th March 22.
No, Your Lordship, in counting length of service, Your Lordship, office memorandum dated 4th of May 2017 is applicable in the incident case, Your Lordship.
Where is that?
Page 36 of my affidavit in opposition. Relevant para is para 5. May I read, Your Lordship? And para 6.
But this is whose responsibility then? Paragraph 6 is whose-
Paragraph 6.
It is,
No.
it will be whose responsibility?
It is the responsibility of the petitioner, Your Lordship. This
How?
OM has been published in the Gazette,
How?
Your Lordship. Now the petitioner is not denying that he is in substitute appointment, and that is counted for length of service for the pensionable purpose, Your Lordship. That is clear in para 6.
No, para 6 does not give him the responsibility to the employee to make that correction.
Your Lordship,
You see, this 4th May 2017,
yes, Your Lordship.
if this was to be followed, then it was the responsibility of the head of the department to make that correction in the service book.
So, Your Lordship, the error surfaced only in 2022 when the circular was issued by PNR, Your Lordship. If Your Lordship may kindly, Your Lordship, I have filed my detailed affidavit, so I'm relying on para 5, 6, 7, and 8, if I may be allowed to read those paras, Your Lordship.
5, 6, 7, 8.
Yes, yes, Your Lordship.
Yes.
Your Lordship, para 5, that with regard to the statement made in paragraph 6 and 7 of the repetition, that it is not denied to the extent borne out of the records. However, the answering deponent would like to further state that in the said office memorandum dated 28/2/2019, Annex 5 to the repetition, it is clearly stated that if there is any mistake or incorrect biodata in the format, it may be reported with relevant supporting documents to the undersigned within 1 month from the date of issue of this OM for necessary action. The petitioner ought to have reported the error committed to
No,
his
just
date
show
of.
me that in your memorandum, that it must be reported by the petitioner. This part, show it to us that the OM
The OM
requires the
dated
4th May 2017, that this is a requirement of the petitioner.
that OM is for content of land of service. And regarding that, the incorrect biodata, that is annexed in the petitioner's petition, Your Lordship. It has been read out from there. Your Lordship, page 27 of the petition. Office memorandum dated 28 February 2019. Your Lordship, second paragraph, if there is any mistake, incorrect biodata in the format, it may be reported with relevant supporting document to the undersigned within 1 month from the date of issue of this OM for necessary action. So, Your Lordship, the service book, till the error surface, it was under the custody of the district sports officer. And since the sports officer failed to do this, step has been taken, your lordship. And regarding this, your lordship, I may be allowed to place how step has been taken against the erring officer.
This is okay.
Lordship,
You see, you'll have to demonstrate in the affirmative and not in the negative. It should not be a negative responsibility of the petitioner.
lordship,
Now, please tell me,
yes,
after this OM of 2017,
yes,
sorry, this 2017,
yes,
you see, this service book was never altered to
yes,
make
yes,
this
it was,
to make this 89
yes,
to 87.
yes,
correct.
yes.
Now, please tell me.
So how it surfaced, your lordship, may
No,
kindly come to
not that. I'm just trying to understand.
Lordship,
In the service book, it is 2018.
service,
Sorry, whatever date, to 1989.
1989.
1989.
It's supposed to
1989.
be 1987,
No, it's
but then it
supposed
was
to be.
entered wrongly as 1989.
It's okay.
Yes,
But do you dispute? You see, you have never in his service career disputed the entries made in the service book. Correct.
lordship.
Now, is it permissible to Mr. Ancient to make a report that 89 is wrong? It should be 87. Can he give a representation against the entries made in the service book?
Your lordship, the entry itself is doubtful because it was during his father's time that the entry was made, your lordship. So that has been pointed out in that letter.
You have never stated here that it was his father who made that wrong entry.
Your lordship, that could not be put on a record. However, the material is already there, your lordship. So lordship may kindly take into consideration, your lordship.
No, it can't be.
But your lordship,
Service matters, it can't be. You must tell us that you see this 89 when it was 89.
89.
At that point of time, there was no OM to guide the officers
Lordship,
that the service would relate back to 87.
lordship.
Now, subsequently, you come with a OM of
Oh,
2017.
yes.
Have you said that this would apply retrospectively to all others who have been already appointed? Can a service notification be retrospective?
Lordship, that is prospective, your lordship. However, but your lordship, it covers why? Because he is still in service when the OM came into force. So this will be applied. This will apply. Otherwise, it will unsettle the settled position, your lordship.
Can't agree to it.
Yes, your lordship.
Can't
And your
agree to
lordship, it has been published in the Gazette. So it is the employees too is expected to be aware of the laws and regulation governing their employment, your lordship. And there is no mana fide. As soon as the error was detected, step has been taken, your lordship.
Lordship, if I may.
No, complete. Let her complete. You have a hurry?
No.
So your lordship, para 6, if I may be allowed to read the para 6, 7 and 8, this will explain the scenario.
Yes.
Para 6, your lordship, that with regards to the statement made in paragraph 8 of the repetition, that it is not denied, the answering deponent would like to further state that respondent number 4, that is the Personal and Administrative Reforms Department, issued a circular bearing so-and-so dated 15/6/2022 to verify the date of birth and the date of joining in service of its employees and to submit for correction in case there is any error in the PIMS data as per procedure laid down in the requisite format given in PNR OM number so-and-so dated 4/3/2022. So your lordship, here it is important. The error surfaced only during this time when the circular was issued by the PNR with necessary documents. The same was forwarded by letter bearing so-and-so dated 23/6/2022. Thereafter, by letter bearing number so and so dated 21/7/2022, the respondent number 3 submitted the details of employees whose age at date of entry into service was either overage or underage, and details of condonation. The name of the petitioner appears in serial number 20248, variant employment code number YRS 00377 of the list of employees underage at first
You see,
employment as per
that statement doesn't help you.
Lordship.
Please come to that page 27 you are showing to us.
Yes,
of
yes.
The
Lordship.
petitioner's letter.
27. Yes,
Does it contain this 28 February 2019? Does it say that the inaccurate biodata in the format must be correlatable to this 2017 notification?
Lordship.
This May 2017 notification, does it link it with that? You get my point?
Lordship, I kindly repeat.
You see, there is a OM of 2017.
Yes,
May 2017.
Lordship, Lordship.
Does this OM of 28 to 2019 correlate to the 2017? You could have written one note here that the format must be in compliance with OM of 2017. After that, he makes a wrong submission. You can catch him, but you don't relate this to that. Can I go and alter my ACR? The service record. Can I go to my office and then correct my ACR?
No, it cannot be done.
It cannot be done. So till the date you don't correct the ACR,
Lordship.
can you say that the entry was wrong?
So, Your Lordship, the entry was wrong. The wrong entry was detected only when this OM 22 circular was issued. So accordingly, step has been taken, and then in accordance with the OM, he has been released from service.
No, release you do it,
But
but you can't now recover. You made extra payment, you will have to, you can't recover that. Because for that you must demonstrate that he is at fault. There is only one requirement after Rafiq Masih. After the judgment of Rafiq Masih, you have to show that he is involved in the fraud or he knowingly give a wrong representation.
Lordship.
If you can fit into any of these two categories, you show us.
Your Lordship, if the matter can come up on Thursday, I'll try to find out some materials from the department.
There is no, because in context with your 35 years service.
Yes, length of service, yes.
As on date, I have not come across any judgment of this court which says that it is the responsibility of an employee to make the correction in the ACR.
No, we are not, that is not our submission. We are not saying that. But he should be aware because he has been serving in a substitute capacity also. So that is counted towards the superannuation. That is what our submission is. It's not that it is the petitioner who should.
His knowledge doesn't create a handicap in his service. His knowledge
Lordship.
does not create a legal handicap in the in service. Unless you see, the ACR is with the department.
Lordship.
Correction, the DDO who is in charge of the office.
Yes.
He is entitled to make corrections after
Yes. He failed. That's why step has been taken to against the erring officer.
No, you are only asking his ACR.
Lordship.
In this letter, you are merely saying that
The biodata and
so and so between the years so and so, whose time the entry of O Mua was made first. So you are only requiring his.
no, that is in respect of the erring officer only.
But
It's
it's
not
not
a
a department.
particular.
This is not a departmental proceeding. Kindly forward us the ACR, APAR of the appointments of two officers.
Yes.
And you also bring smile to me when I read this letter. Who is higher in your hierarchy? It is the director or it is the commissioner?
It is the commissioner.
So junior officer write to the senior officer.
Yes.
On this subject, I have the honor to request you to kindly forward the ACR to me.
That is the director writing to the district officer.
No, to the commissioner. He's writing to the commissioner, he's directing the commissioner to provide him with the document. Look at this letter.
Yes, yes. Have a look at it.
A director can't touch the ACR under the establishment of the commissioner. He'll have to merely bring it to his notice to the commissioner that this has happened. Please take appropriate steps. We bring it to the notice that this has happened.
Yes, yes.
I would do everything,
yes.
stop short of commanding my Chief Justice to do
Thank you,
something.
Lord. Yes.
But this is a gap. I don't find anything to connect 2017 with 2019.
Your Lordship, there is no
And-
dispute that the petitioner.
And you
has
see,
served in
second thing I fail to understand,
Lordship.
this 2019 letter
Yes, sir.
is with regard to seniority list.
2018.
No,
Yes, yes,
I just wanted to know from you,
yes, sir.
when does the office issue seniority list with intimation that any mistake or inaccurate biodata must be brought to his notice? What is the why are such OMs issued?
Which OM, Your Lordship?
27, page 27 from the
Page
petition.
27, yes, yes, yes.
It relates to seniority lists. I just
Yes,
wanted
it
to
was,
understand,
yes.
when does this communication is made to all the employees whose name is there in the gradation list
Yes.
to point out inaccuracies or mistakes? What is the occasion? Because to my limited understanding,
Lordship.
these are accompanying the gradation list, because if in the final gradation list there is some mistake,
Mhm.
draft gradation list, there's some mistake, point out.
Lordship.
Final draft also, if it is circulated, then also if something inaccurate has remained, please tell us.
Lordship, Lordship. Lordship, regarding this OM, Your Lordship, let the matter be listed on Thursday. I'll get some clarification from the department.
Worship, actually, I see page 28 was of this same memorandum.
28. Yes,
Worship, may kindly come to serial number 24, man.
24.
24. This is in 2019, man. May I kindly see column number 5, man. Date of appointment 1489 till 2019, man.
Well, that is the mistake they are committing.
Yes.
And then
You
date of
otherwise ought to
employment.
have retired.
Yes, so my lord,
You ought to have retired earlier, but
no, all along, my lord, they were taking it. And then kindly come to page 29, my lord. For the first time, they have taken a stand only in 17 April 2023 that I ought to have retired in 2022. May I just read this, my lord. On the subject cited above, it refers to your letter number such, my lord, the director writing to the commissioner. I have the honor to inform you that the department has been maintaining record seniority of more under the establishment of BSO Mokchung as per his date of joining as 1489, entered in the service book. However, it was found to have been recorded as 1489 under PIMS. As such, the department wrote for correction where later dated as such. However, upon requirement of the first appointment order as sought by the PNR department, conveyed by letter number such, the 38/2022, we are able to find it from the all records file under the Directorate Office. The same was submitted by letter number such dated 25/11/22. As such, it is hereby stated that 2187 is the actual date of his first appointment and 1489 is the date of service regularization. Hence, the department earlier request to correct the date of joining from such and such to 1489 may be treated as cancelled and the inconvenience created is regretted. So this is the first time, my lord, the department itself is taking a stand that my date of appointment should be counted
No,
from
whatever, be,
1987.
but I agree to her stand that your retirement should have been earlier. But once you have served, that
No
permit
fault
cannot be
on
withdrawn.
my part, my lord. Absolutely no fault on my part. I've made specific category pleadings in my writ petition also. They have not denied that also.
Okay, give her some time, let her produce whatever she can.
Lordship, tomorrow, my lord, Thursday, I'm sorry, my lord, Thursday, I have a trial matter. my lord.
Then
In the-
Wednesday,
In the,
Wednesday, Lordship, it used the SD. Usually there used to be a DB. So. Wednesday.
DB may not be for the whole day. Try to see. Both sides are represented. After the matter being heard for some length, the learned government advocate submits that the matter be taken up on another day. Just list on, make it Wednesday,
then,
10th.
Obliged, Lordship.
For admission, item number 1.
Please, Your Lordship.
Yes.
Your Lordship, I received an instruction that on 7th August 2025, the case of the petitioner has been forwarded to the PNR again, Your Lordship. There was a requirement that the petitioner who has undergone a verification in 2014 and 16, that should be submitted to the PNR. Accordingly, the department taking the documents has forwarded the case of the petitioner. Your Lordship.
We wait for
So-
some time.
So
Okay.
sometime maybe granted again
Okay.
for,
Both
Right.
sides are represented. I forgot your name, Miss Livika.
yes, Your Lordship.
Ms. Livika Lanan, government advocate, submits that as per instructions received, verbal instructions received by her, comma, the relevant,
No, so I received the comment, Your Lordship.
written communication, comma, the relevant documents of the petitioner has since been forwarded to the which department,
PNR, Your Lordship.
full name,
Personal and administrative reforms.
Personal and Administrative Reforms Department. Stop. In view of the said submissions, comma, the matter stands adjourned today, list after 3 weeks.
Your Lordship, make it 4 weeks because since the case of the petition is under consideration, so. it's
Okay,
process,
after
so-
4 weeks, the only government advocate shall produce updated instructions on the next digital listing.
Much obliged.
For admission, item number 8.
Yes.
Your Lordship, here, I'm appearing on behalf of AIM. I'm informed that she has already filed the affidavit. The state has already filed.
Who has filed affidavit?
The state. The state has already filed.
Ah, yes, it's been filed.
May I please, Your Lordship? My Lord, I'm appearing on behalf of my senior for respondent number 5. We are yet to file our affidavit.
Who is respondent number 5?
Office of the Accountant General.
Accountant General's affidavit is not required in the matter.
Lordship. Yes, we don't have any.
Accounts has nothing to say.
Lordship,
It's a prayer for regularization.
yes, Lordship.
Accountant General has no role to play in this matter. Achha, just tell me in this case, have you superannuated in the meantime?
Your Lordship, my senior is out of station. I'm
No,
not
but
in this project.
can somebody tell us whether the petitioner has superannuated in the meantime?
His lordship, on completion of 35 years of service, the petition.
She's superannuated. No, then your writ petition would not be maintainable. You have come to court after your retirement. You will adjourn it. Both sides are represented on the prayer made by Learned Counsel for the petitioner. The matter stands adjourned today. List after 2 weeks. I should just before that you say, please for adjournment. The Learned Counsel for respondent number 5 also prays for adjournment. Next, on the next date of listing, the Learned Counsel for the petitioner shall address the court on the issue of delay in latches as the petitioner is already superannuated on attaining on completion of 35 years of service on
31/02/2018.
31/02.
February 2018.
31/2.
Yes, lordship.
No, there is no 31 in February.
Release order dated 31/02/2018.
If Nagaland has a calendar of 31 days in February,
January, lordship.
January, okay. 31 January 2023. 23.
2018, 31st January 2018.
18 here, 18. Okay. List after 2 weeks.
For admission, item number 9.
May please your also.
Yes.
I am for the applicant. This interlocutory application has been while seeking the commitment of necessary parties in the ongoing week vision, week of 2021.
What is the reason you want to join? Who are you?
I am necessary, I should be a necessary parties in the ongoing week petition number 63 of 2021.
Why? What is your interest?
The opposite parties get me speaking time.
Lordship, I won't be filing any objection to the IL, Lordship.
No, it's not a question of your objection, but
Yes, sir.
why do you want him pleading?
They are claiming that they are the actual owners of the land, Your Lordship, of the land in question.
Your Lordship, the subject matter in the petition pertains to a land, particularly a land measuring an area of 1.9 acres.
Yes.
Originally owned by Kopinath Paira, Lake Kopinath Paira. Your Lordship, the present applicants are the grandchildren of Lake Kopinath Paira. So they are also the rightful and legal owners.
Who is the petitioner? You are the petitioner.
I don't, I agreed by the order of the respondent deputy commissioner. The deputy commissioner has passed an order infringing the Nagaland and Revenue Act. So because of that, I'm filing the street. I'm filing the street.
Where is this 79/2014 letter?
My petition, the corrected copy, the type copy is page 77.
My lord, I want to come to page 39. 79. So on the page 79, the period rate and per square feet. This has been hiked by the deputy commissioner, the respondent number 3. I'm agreed by this order. Now, my lord, coming to page 94. Coming to page 94, says act passed by the state. Nagaland Land and Revenue Regulation Act. Page 94.
Yes.
So page 94, the state of Nagaland has amended this act. Amended this act, and my lord, in page 95. Page 95. Rule 30 and 31. Rule 30 and 31 states that the state government has the authority to review the rent of the land.
What does this have to do with your claim for rent?
My lord, as stated in page 79, the deputy commissioner has no authority. The deputy commissioner is only the settlement officer. So the deputy commissioner is not the state government. And for that, he has no authority to hike the rent of the land in question. That's all.
Deputy Commissioner is not the state.
State government. My lord, coming to page 38. Page 38 of my
You-
brief. My lord, this is a notification passed by the Land Revenue Department. So is the notification from the government. Now,
Which
as
page?
per-
Which
yes,
page?
Page 38, my lord, my lady.
Yes.
Yes, page 38. So page 38, I read out. It's not much. Whereas the government of Nagaland is pleased to reiterate the department earlier notification number so in connection with the land required by the central government department and agencies by this notification of even number so and wherein it was already notified that all land required by the central government department and its agencies, including public sector undertaking of the union government or other parties, shall be first acquired by the state and leased out to the concerned department or agencies or parties subject to the approval of the government for 50 years initially. And whereas the government of Netherlands is pleased to reiterate the department earlier order number so and so, dated 89 to charge ₹200 per acre per annum as temporary occupation of land rent on public as well as government acquired land, which are under occupation or to be occupied by lease, that is central government department, agencies and parties in Nagaland. Now, therefore, the government of Nagaland is pleased to order and notify that all central government department agencies, including the state, including the public sector undertaking of the union government, as well as private sector undertaking of non-indigenous origin who have already obtained land allotment from the deputy commissioner of various departments shall be conferred into these deed, and those department of organization, etc., who are now looking for land may do so on payment of land premium plus land grant. The deputy commissioner is directed to initiate these agreements with those central government department agencies in the respective district to set the land and revenue report in a correct prospective state of affair from now onwards, signed by the secretary government. Now, my lord, the deputy commissioner has hiked the length of the rank. So the deputy commissioner order 17/9/2014. I'm challenging that one. Here, the deputy commissioner has hiked the rent of the land. The government order is clear that a notification they have already hiked it. Now coming to the Nagaland Revenue Act. The deputy commissioner has no authority. It is the settlement is the deputy commissioner who forwarded the matter to the state government. Then from there on, the state government hikes the rent or seat it. Now here the deputy commissioner has hiked the rent of land. That's all. So I'm saying the deputy commissioner has no authority, and so this order should be quashed. That's all.
Okay. Yes, for the government who is making submissions.
Your Lordship, for the DC, Your Lordship, I appear for the DC. However, Your Lordship, and it's very unfortunate that Your Lordship, I need to receive instruction. So that is the technical problem.
This is 2021 matter, 20
Yes, Your Lordship.
2021 petition.
Yes, Your Lordship.
You have to, this is, you see, even if you have instructions or no instructions, it's a question of law.
Yes, Your Lordship.
Who will issue the notification of enhancement of land revenue? You have to only answer that.
My lord, that order is passed on dated 23/24. So he also he has really instructed the state to make the report. Till then, there's no report as such. So
Your Lordship,
I feel
last,
that the order may be, the
last-
order of the.
last gracious time may be granted to me, Your
No,
Lordship.
but
So I will
Yes.
extend the instruction to this.
no, instructions don't do. It's a question of the authority, who will do it. I'm sorry, I forget names. You are Mr.
Elvis Zhao.
Zhao, Mr. Zhao. I'm sorry, I'm forgetful. I'll come after some time. You see, the submission of Mr. Zhao is very simple. He says that deputy commissioner is not the state. And therefore, he could not have given the fix the rates of rent. Now, you have to only show that he is a state, he is empowered by any authority to issue notification of enhancement of the land revenue.
Your Lordship, as far as the facts are concerned, the respondent will able to appraise this court properly, Your Lordship. But on that question, Your Lordship, this notification 12 of 2016, it speaks about, Your Lordship, on the acquired land, Your Lordship. At that point of time, Your Lordship, the land was not acquired, it is a private land. Your Lordship, so the state government, the DC has the power, Your Lordship. This talks about, Your Lordship, acquired land, Your Lordship, the central acquired land. At that point of time, it was not acquired.
Where?
That the 12 January 2016, which my learned friend is page 38, Your Lordship.
23 of the rate petition.
Yes, Your Lordship. My learned friend has already read out this now, Your Lordship.
23 of the rate petition is Jamabandi.
38, Your Lordship.
38.
Election for.
38.
You got it, Your Lordship. 12 January 2006. 12 January 2006.
Departments of them. So this, in this document, in this bunch of document, there is one lease agreement.
Yes.
Page
25.
25. So this is the agreement.
Is it?
Now, this agreement has not been assigned to the government. You see, I'll tell you what I feel. That's why I took up the hearing. The land levied is for the landlord to pay.
Yes.
It's not for the Union of India to pay. Therefore, the writ petition by the Union of India, I could not understand. You have got nothing to do with the payment of land revenue. It is for the owner to pay. And between you and the owner, there is an agreement to pay rent. So how can you be aggrieved?
So I don't care in the agreement lease. In the lease, it is 60 rupees.
No, we are not bothered by that. You see, so far as you and the landlord is concerned, you are a tenant and he is the landlord. Correct? Is it your concern that the landlord is paying 200 rupees and charging you 60 rupees?
My lord, we have been following this.
No, that's okay. But I'm just asking you a question. You are the landlord. Now you change role. You are the landlord. You have given rent of a room in your house to A. Correct? To A, he is well known to you. You charge only a token 100 rupees as rent from him. But because of the rate assessment of your property, the, let us say, Kohima Municipality or Kohima Town Committee is charging you 500 rupees for that room as rates and taxes. Is there any bar that the landlord cannot rent out the house to the tenant at a lesser rate than the revenue paid? No.
You know, there is something to government. I'm for you.
So therefore, it is between the landlord and the what you call the challenge should have been by the landlord, because you don't pay rent to the government.
I will pay.
How you can pay?
Yeah, it is on page 47. It's okay.
Does this agreement say that the rent has to be paid by you? The land revenue must be paid by you. Is it said that?
I've been paid.
Huh?
Here it's page 47, my lord. I want to be paid the revenue of.
No, you may be paying. You that is gracious act on your part. But this must say that the liability to pay rent to the government is on you.
Yes.
Where is that?
Thank you, Your Lordship. This page 47, this is dated 12 September 2013, Your Lordship. So, Lordship, the land was acquired on 2012. Acquisition proceedings was done in 2012, Your Lordship. So from 2012, the land belonged to the Seva, Your
Government.
Lordship. Yes, Your Lordship.
Where is that?
Lordship, page 47 is 11 September 2013, the receipt. This is the reason why revenue was paid by them, Your Lordship.
Land cannot be acquired by a receipt.
Acquisition proceedings were done, Your Lordship.
Where is that? Yes, you are for the landlord. Do you agree? Land has been acquired.
Lordship, in the land read, I'm not yet reading.
Whether you are there or not, that's not the issue. You have come for impleading.
Yes, yes.
So we are for the purpose of impleading, we are hearing that.
This is page 50, Your Lordship.
50.
Page 50 of my affidavit, Your Lordship.
50 of your affidavit. We are asking you a question, do you admit that the land has been acquired by the government?
Portion is from page 55.
Oh. Then we are rejecting your application for impleading. Once the land is acquired and there is a rateable judgment at page 57 affirming the land acquisition, your impleading application has to be dismissed. In a case where the quantification of rent is challenged by the Union of India, you are nobody.
Against the judgment, the union also approached the apex court, Your Lordship, which was also dismissed, Your Lordship.
Because there's a letter of the SLP being filed, but the order of the SLP is not here. At least I did not find it. In their document, they have annexed it, but we don't know about the fate of that SLP.
It's 74, Your Lordship.
Page 74, yes. Okay, it says dismissed on withdrawn. So we are dismissing your application for impleading. Because you can't be impleaded in this case. There is no cause of action against you. Your name is Mr. Takao. Please write the spelling, I may make a mistake. But Mr. Takao, and the counsel for the applicant. Also heard. Mr. E. Zhao. Leonard, you are CGC? Leonard CGC appearing for the respondent number 1, 2, and 3. For state, who is appearing? For state, you are appearing?
I'm going to respond number 1, Your Lordship.
No, in the application. This is the interlocutory application we are. In this interlocutory application, 1, 2, and 3 is Mrs. Howe. 4 is Ani
Yes, Your Lordship.
Peria. For the Miss.
Esther, Your Lordship.
Just write it down. I may make a mistake. Responsible Learned Counsel for the respondent number 4, and Ms. Livika and a government advocate appearing for respondent number 5 and 6. Your designation is government advocate?
Yes.
Okay. 4, 5, and 6. Next paragraph. The applicants, namely Sri Nanu Rana, put up page 3. Raju Rana and Srimati Meena Rana have filed this interlocutory application for being impleaded as respondent numbers 4, 5, and 6. In the connected WPC 63K of 2021. Next, madam. The applicants project that the land, which is referred to in the connected writ petition, originally belonged to their predecessor in interest, which was under the occupation of the Border Road Organization, public SEWAK, SEWAK, on lease since 1962. It is further projected that the said land was not mutated in the name of 3 daughters of late Gopinath, Gopinath, Paria, Paria, who was the original landlord, original owner of the said land. Accordingly, claiming that the applicants would have equal rights to succeed the estate of their deceased predecessor in interest. Claim interest in the land, referred to in the connected writ petition, full stop. Moreover, it is also projected that the respondent number 1, in whose name the said land is currently mutated, has since converted into a Christian, and therefore, the respondent number 1 has no right, title, or interest to the property which otherwise belongs to the co-parsoners of the Hindu undivided family. Next para. On an examination of the connected writ petition, it is noticed that the respondent numbers 1, 2, and 3 herein, being the Union of India and authorities thereunder, have assailed the impugn order dated 17/9/2014, within bracket, annexure Roman 13 to the writ petition, by which the Deputy Commissioner, Dimapur, had enhanced the rent payable by the occupier of the government acquired land. And the challenge is, full stop, the learned CGC has submitted that the challenge is made on the ground that the Deputy Commissioner, for the purposes of this of issuing of the notification for enhancement of rent, comma, is not a state, and that the notification of rent for the land has to be notified by the state government, comma, which is the commissioner secretary.
No, it is the state government. It has to be,
State government is who?
state government, it has to be secretary or the additional or the other secretary.
Secretary or higher, commissioner is also government. The state government by its secretary of the concerned department or any higher authority thereto, who's empowered to act as a state, as a secretary to the said department. Next para, the learned CGC has also, no, sorry, the learned council for respondent number 1. No, it will not respond 1, 2, 3, 4. Has also pointed out that a land acquisition case which was registered as land acquisition case number, just a moment, Rev REV -17 / 2005 D / 2012 / 1442. Yes,
Worship, the pata issued in the name of any para.
Is under challenge in the lower court.
coming the challenge, how can you interfere in his writ petition? He is asking that the rent is high. How can you challenge, how can you impede yourself here? You're not getting that rent. It will be the government who is collecting the rent. What is your what you call involvement in this? How you are aggrieved if a writ petition decided in your absence?
Your worship, the applicants came to know of the illegalities only,
Only in the year 2024, when any para transferred to some 10 lakhs into the account of one para. There is one of the son of Kohima para.
In the writ petition is she claiming anything? No. It is the writ petition by the Union of India. And Union of India does not want to pay this land rent either to respondent number 1 or to you. They are fighting it with the government that it is high. How you are the aggrieved party?
your worship, since your worship, the present applicants should be, in fact,
No, you are not a necessary party. This is strictly beyond between you and the government, the Union of India and the government. You can't do anything. You are not a necessary party. The contours of the writ petition cannot be changed because of your presence. If you can show that yes, I was the this notification of land acquisition never took place, then we can understand. This notification is already there. Was initiated regarding acquisition of land belonging to respondent number 1, occupied by Project Sevak, having a total area of 5 bigha, 4 katha, 1 lacha, within bracket 1.92 acres ACRES. And it has been submitted that by an order dated 25/10/2012 in the said acquisition proceedings, direction was issued to Project Sevak to deposit the awarded sum of rupees 7,69,45,120 in terms of the directions contained therein. She also submits that the Union of India that the opposite parties number 1, 2, and 3 make it respondents 1, 2, and 3 in this interlocutory application had challenged the said order before the learned single judge by filing WPC 114 K of 2014, which was dismissed, and the said order dated 15/5/2017, dismissing the writ petition was assailed by filing WA 4 of 2019, which was also dismissed by the division bench of this court, and that the said order was challenged before the Supreme Court of India by filing petition for leave to appeal, petition for special leave to appeal within bracket C, bracket code diary number 635/2021, which was also dismissed on withdrawal by order dated 23/7/2021. Next paragraph. Although the learned counsel for the applicant has submitted that that in the pata issued for the said land, the applicants were also the recorded owner of the said land. Next paragraph. No, not as well, nonetheless, as the acquisition proceedings have already taken place and the state government has acquired the land in question, for the purpose of the nature of challenge made in the connected writ petition by the respondent numbers 1, 2, and 3, the court is of the constitutional opinion that the applicants herein are neither necessary nor an appropriate party, nor a proper party to the writ petition, as the issue of enhanced rent demanded by the state through the orders passed by the Deputy Commissioner is under challenged by the respondent numbers 1, 2, and 3. Next, accordingly, the court does not find any merit in the impleading application, and therefore the this impleading application stands dismissed. Now, in the writ petition, what do you say?
Under plus brushes can be granted to me so that I will bring the complete instruction.
Okay. Next paragraph. The main writ petition. What says the represented? Next paragraph. The learned CGC has, Mr. E. South and the CGC has submitted that the order impugned in the writ petition is sailed on the ground that the Deputy Commissioner was not the competent authority to issue an order to enhance the rent payable for the land under the occupation of Project Sevak. Full stop. Next paragraph. The learned Ms. Devika and the government advocate prays for a last Prays for some time to obtain instructions. Next para. Having noticed that this writ petition is of the year 2021 and the notice of motion. Notice of motion was this notice was never issued in this case.
Your Lordship, I got the notice only sometime in the year 2020, last part of 2022, 24, Your Lordship. But yes, Your Lordship, and only then I could serve notice, Your Lordship. Initially, I didn't got the notice, Your Lordship.
And nobody pointed out.
Constitution of 12/6/2023.
12/6/2023.
Yes. The state.
There's no order of 12/6 here. After 25/5, we have the next date on 19/6. No. Just check up. I'll take a 2-minute break. In the meantime, please check up. I don't find notice being issued. But I may have missed it. Here's the order sheet. I'm not getting it. If notice is not issued, then you say that it is noticed that the matter was first listed on so and so. And despite opportunities granted to the state respondents, no affidavit in opposition has been filed. So accordingly, one last chance is granted to the state respondents to file their affidavit in opposition, filling which it can be presumed that the state respondents have
10/8/2023. I got the service copy.
Minority, it's been received on 12/6/2023.
I don't know
We
since
made
I
a
missed it.
submission. Made a submission.
No, 10/8 does not say that notice was issued. I want the order of notice being issued. I am not concerned with, there are many orders directing you to do it. I want notice of motion whether it was issued or not. Just check that.
Copy was just given to me.
No, we are not concerned with that.
Your Lordship, then
You see,
notice
for
was-
2 years, you are receiving directions to file affidavit, but you don't have copies. You did not point out for 2 years. That is your fault.
So I told them to give me a copy and accordingly I served the.
No,
copy.
this can be tolerated.
That
You notice was issued long back and you've not been careful about it. Yeah, but one last opportunity of 3 weeks is granted to the state respondents to file their application opposition, failing which the court would be inclined to invoke the doctrine of non-traverse and deem that the state respondents have removed the claim of the writ petitioner and appropriate orders will be passed on the next date of listing. Just after 3 weeks.
Much obliged.
I'll take a break and come back.
For admission, item number 10.
We don't have any believing. Issue of this motion within about 3 weeks.
Maybe Sir Lordship.
Yes.
Lordship, I'd like to mention on behalf of the Indian Sang Action Agent Lordship. Lordship, here I'm here to receive instructions, Lordship. And I was instructed that the Union of India and the National Highway of India, they are the main respondents, Lordship. So here's that is just a felicitated, Lordship.
This is a challenge to the land acquisition.
Yes, Lordship.
Who is for Union of India?
The Union of India not appear to live, I believe, Lordship.
Yes, my lord. I'm for the petitioner, my lord. This matter has been composition still delayed for filing a contract affidavit by the respondents. And as per the order of this law, there is 7 October 2025. Last opportunity was given to the respondent to file their.
No. Where is the document of that you have served the notice to the CGC?
Yes.
Where is that? In this repetition, you have not served it to him. Just show it to him. Service copy has not been served. How could you file the writ petition?
So seventh police was,
Show it. You have a CGC here. In the last page, you don't serve it to him. No, no, see the last page. Don't turn any other page. See the last page. You don't serve notice to him. How could you file it? No, you have to serve copies to the CGC. How many? How many unit respondents are there? National Highways has a standing council here, no?
standing council says.
Huh?
Yes, it was.
You serve copies and then come again. Serve extra copies to them and then bring them here. We'll take it up at 2 o'clock.
My lord, last time they appeared in person, so I forget.
You see, unless you show me service of copy, if you have given him a copy, show me the acknowledgement. We'll move ahead. If there are standing council, you have not served them copies. I've shown you the document. Unless you show it to me, you see, I don't carry knowledge what my predecessor in the office had. Earlier, judge, you made submission. I don't have that knowledge. Whether he appeared or not, we don't know. You show us that you have served him copies and then we proceed in the matter. We don't serve copies. That is very incorrect way of filing it. You could not have filed it. And the court registry should not have entertained it.
Let me trace it out him.
Yes, do it. We'll take it up at 2 o'clock. Give them copies, serve copies, and then come again. We'll take it up at 2 o'clock.
Joshua, for the state respondents version.
We'll take it up at 2 o'clock. And we're not passing any order. Let him serve copies and then come. We'll take it up at 2 o'clock.
Yes, Josh. Observe, Josh.
For admission, item number 13.
Yes.
Yes, Lordship. Lordship, our construction item of the respondent number 4 and 6. The medical department, principal director and the chief medical officer. Lordship, here the petition is directed against the policy decision of the government, whereby the government has framed a policy how landowners will be appointed 5th March 2018. Now, since the matter pertains to the policy decision, Lordship, the chief secretary and the land review department, who are the concerned department who has issued a notification, they will be the right person to file the affidavit. As far as I'm concerned, Lordship, I'm preparing my affidavit, Lordship. So I pray for 2 weeks' time.
Okay.
In fact, the policy decision was framed based on
No,
the
it is-
direction of the chief justice. Bunch of repetition was taken up together by the chief
Earlier, it
justice.
was you're required to give them a job.
Yes.
That
Now,
was
the policy is now, if-
freely donated land.
yes, only against freely donated land. Here's a case where the petitioner's grandfather has taken, he sold his land for an amount of rupees. For an amount of rupees 3 lakhs. Now the grandson is coming and saying that there is an agreement. There is no such agreement, Lordship. We never entered into any agreement with the landowners. He himself, his grandfather is acknowledging that I have sold my land for 3 lakhs. And then when any grateful appointment arises, preference will be given to me. But that is as a declaration by the landowner, not an agreement, Lordship. So we are raising our objection on that.
But you have to file in the response.
Yes, Lordship, 2 weeks private granted, Lordship. I'll be filing within the time. Yes, it's not just. Yes, I'll be appearing for 1, 4, and 6. 1 is the Commissioner Secretary, Department of Health and Welfare, Lordship. 4 is the Principal Director, and 6 is the Chief Medical Officer. They have not included the chief secretary initially. So by an order of this court, the chief secretary was made a party. And chief secretary is the respondent number 8. Recently, Lordship.
No, Constitution was never amended.
They were directed to file amendment process. What's right?
By order dated 6/6/2025 in IA 87 of 2025.
No, but that has to be incorporated here.
Lordship, we have filed the amended cost title.
You file it.
Yes, Lordship.
It was just a change of one page.
No, whatever be, but it is,
Lordship, we have filed it on 17/6/2025.
just tell me, what is the system here? This amendment has been filed, but it is not incorporated here. Why? Can you?
Lordship, if any amendment is made, Lordship,
No.
the whole amended petition should be filed.
No. Under the new rules, only the amended cost title is required to be filed, but this must go here. No, here it is. Just come here.
In the
Come inside. I'll show it to you. You see, you have to talk to our deputy registrars. In principle seat, what we do when this cost title is amended, they have filed it. No? This must go here. Main petition. In the main petition, because when I look at this file, I will only see here. So you inform them because there must be some way where this can be substituted. Because I only read from here. So in the principles, what they do is that this is incorporated here and a note is put up in the note sheet that the amended cost title is made up out of record. This is how we do the. Okay. Let's just talk to them. Okay, because in the principal sheet, we are following a different pattern. What we do is that the amended cost title is incorporated in the writ petition because I am trained to look into the writ petition, not in the other documents.
Lordship, yes.
She has filed it, but
It's
it
not
escaped my notice.
Yes.
Okay. Because the principal sheet we incorporate in the writ petition.
Lordship.
It is opened and inserted and then
Lordship.
received. Okay. We give them 2 weeks time.
Lordship.
Your Lordship, I'm representing respondent number 2, 3, and 5.
2, 3, and 5.
Respondent number 2 is the Commissioner Secretary, ANR. Respondent number 3 is the Secretary, Department of Land Revenue. Respondent number 5 is the Deputy Commissioner, Kohima.
Okay.
And your name is respondent number 8, that is the Chief Secretary to the Governor of Nigeria, is represented by MD Song, Additional Advocate General. I am Indian Senior Advocate representing 2, 3, and 5. 2,
Okay.
3, and 5, Your Lordship.
You are for 2, 3, and 5.
Yes, Indian Senior Commander. And
I will just record it. Your name is?
Pim Hombeni is for the petition.
Please write it down. May make a mistake. Correct. Give them a slip. Write the name because I may make a mistake. When counsel for the petitioner also heard Mr. Mohanchen Danet, senior government advocate for the state of Nagaland, and Mr.
And Mufid.
and Muzid, learned
Engaged counsel.
counsel for respondent numbers.
Medical Department.
Respondent numbers 1,
4, and 6.
1, 4, and 6. And is notice served on respondent number 7?
Respondent number 8.
No, 7.
7 is.
Lordship,
In fact,
we have served notice through dusty service. However, till date, none has appeared. And
Where is that affidavit of the service?
to that effect, we have filed our affidavit on 15/7/2025.
With regard to this service, you see, in your affidavit of service, you say that you have served it, the lawyer has gone there and served.
Lordship,
In this affidavit of service,
Hmm.
the deponent is a lawyer.
Lordship, yes,
He goes and says that I have served it to the respondent number 7
Lordship.
in presence of a witness. Now, these two statements are lacking. Number one, who has identified this person? Obviously, you would not know, as a lawyer, you would not know the respondent number 7. Who identified you? And second is that the witness, his name you don't say anywhere in that. You see, I have a natural doubt. It's not that we are doubting your statement, but the fact is that how does a lawyer know the respondent? Somebody must have told the address, somebody must have shown the house, somebody must have told that he is so and so.
Through our client,
Hmm?
through our client.
But the identification, all there's no statement in the affidavit. And you see, why should a lawyer go and give service? A lawyer is not a. We can't demean a lawyer to make him or her a postman. Why would a lawyer go and then? You serve again through registered post with AD. You collect the postal receipt number and give us the track report.
Lordship, I pray that we may be allowed to serve through Dusty and
You may serve by Dusty, but don't make a.
Lordship.
Don't get it signed by a lawyer. We may put some uncomfortable questions. We don't want that. Because he becomes a witness to a proceeding. A lawyer becoming a witness to a proceeding is again something I would be very unhappy. And is he the counsel on record?
Lordship.
Then he has to be now recuse himself. He can't be a counsel then. He has turned into a witness.
I pray that I may be allowed to issue fresh notice.
Because for these things we engage, you see, I'm telling you, it's not, we are a young lawyer, I'm just, that's why I'm telling you. You see, he becomes a witness. And as a witness, he can't be there as a lawyer also. There's the difficulty. Second is that the service of order of Dasti service was made to you. You means the client. The service will be made and the affidavit be filed. Service by a third party is not permitted
I'll be careful.
because please remember that because the order says that the petitioner shall serve by way of Dasti. Is it not? Because the direction to the council is always direction to do compliance. The direction here that the council for the petitioner shall take steps does not mean that the lawyer should go there and take personal service. Right? We are not saying anything. We don't want to make any observation, but we only say that the steps by registered post be taken again. Right? Next, by the learned counsel for the petitioner has submitted that amended cost title has been filed and brought on record. The chief secretary, you will appear.
Additional AG, Mr. Intim Song.
Acha.
Yes.
Before that, you write, the learned additional advocate general appears for the respond number 8. Then that will come. Next paragraph. As a matter of abundant caution, the petitioner is directed to take fresh steps for service of notice on respond number 7 by registered post with AD. Next paragraph, the learned counsel for the petitioner is at liberty to collect the postal receipt number and to submit postal track report prior to the next date of listing. Next paragraph, the learned counsel for the health department prays for further
2 weeks now.
2 weeks time to file affidavit in opposition in the matter.
Okay.
This notice on 7 on respond number 7 is made returnable. Give a fixed date after 4 weeks. It's made returnable on so and so. The affidavit by the state respondents shall be filed at least 2 days prior to the next date of listing. List on so and so. Okay. 6th of October. Okay.
Obligation, Lord.
For admission, item number 21.
But is it Lordship?
Yes.
Lordship, here I'm mentioning on behalf of my colleague AIMA. Your Lordship, this is the second time after the motion has come up, Your Lordship. She has received an oral instruction that the case of the petitioner being genuine has been forwarded to the PNR for clearance. However, she is yet to receive that copy, Your Lordship, the official copy. Though she has been instructed that on being genuine, the case has been forwarded, but that official copy we are yet to receive, Your Lordship.
Both sides are represented. Ms. Devika and Government Advocate submits on behalf of a colleague holding the brief that as per verbal instructions received, the case of the petitioner has been processed and sent to the concerned PNAR department for doing the needful. So she prays for some time to obtain written instructions in the matter. Next, accordingly, matter stands adjourned today. Next, the pendency of this writ petition shall not be a bar for the concerned respondent authorities to process the claim of the petitioner for release of his pay and allowances from the date of joining of service, i.e. from 9/6/2023. List of 3 weeks.
For orders, item number 22.
Yes, Your Lordship. The service report upon respondent number 10 is still awaited.
Pardon me,
Service report upon respondent number 10 is still awaited.
respondent number 10.
Yes, Mr. Contractor. Can you allow me to take fresh steps by way of Dusty?
The petitioner and the respondent numbers 1 to 9 are represented. Next slide. As per the office note dated 19/8/2025, service report on respondent number 10 is awaited. Next per the on the prayer made by land council for the petitioner, the petitioner is directed to take fresh steps for service of notice on the respondent numbers. Respondent number 8,
Respondent number 10.
sorry, 10, I'm sorry. Respondent number 10 by registered postpaid ID at both the addresses of the said respondent. And in addition, the petitioner shall also take steps for service of notice on respondent number 10 at the Kohima address of the said respondent. Stop steps within 2 days. The notice is made returnable on 6/10/2025. Next paragraph. On service, an affidavit of service shall be filed prior to the next date of listing. List on 6/10/2025.
Lordship, interim may be continued. Interim may be continued.
Okay. What is the interim order?
The respondent number 5 was to take a site inspection on the petitioner's land. Order dated.
No, this will not help you. Who is for respondent number 5? You are for 5. Where is that report?
On 7 August 2025, respondent number 6 has given a circular. However, we have not received the report yet, just the circular.
Next para on the, in view of the order passed on 18/7/2025, the learned counsel for the learned CGC, state and departmental council shall inform the court regarding compliance of paragraph 7 of the said order. List after how much time?
3 weeks session.
2 weeks.
3 weeks session.
List after 3 weeks.
Right.
Next para, before that, you say the learned government advocate shall send a downloaded copy of this order to the additional deputy commissioner, Futsero, PFUTSCRO, Nagaland. You send this order to that authority.
Yes, Lordship.
Okay. There is no interim order to be extended. It doesn't help you.
For hearing, item number 23.
Is your lordship.
Yes.
Your lordship, this instant appeal is filed by the appealant, that is United India Insurance Company, against the impugned judgment and order dated 23/2019, passed by the learned member University of Mapo. Your lordship, what has happened in this case is that initially the deceased claimant, that is a wife, husband of the respondent number 1, has filed a claim case against the external injuries sustained on 5/10/2011. However, during the pendency of the case, the deceased claimant expired, and after it was substituted by the respondent number 1, 2 and 3. Your lordship, without taking in consideration of the evidences from the proper perspective from the by the tribunal, has passed an award amounting to rupees 19,65,690. Being aggrieved by the said award, your lordship, the appellant has preferred the appeal on 3-4 grounds, your lordship. The first ground, your lordship, I would like to take your lordship to page number 5 of my opinion.
Yes.
The first ground is that the accident happened on 5/10/2011. And thereafter, the deceased claimant filed the claim case. However, during the pendency, it was after 21 months of the accident. The deceased expired. I mean, the claimant deceased expired. There was no postmortem. Expired on 19/7/2013. Their accident was 5/10/2011. No postmortem was produced before the tribunal to establish that the deceased died out of the accidental injuries sustained. They have submitted some extra reports. However, opportunity was not granted to the appellant, that is the insurance company, to cross-examine in order to establish that the cause of the death was due to the accident. This is the first ground which I was.
Did you file a petition to cross-examine? How will you understand that you prayed for and you were not granted an opportunity?
Your Lordship, documents was not produced by the claimant for the tribunal.
No, that's not correct. Documents are there.
Postmortem, Your Lordship.
No, postmortem,
In respect of postmortem, because in order to establish the cause of the death,
no, you can't say whether the postmortem was required or not. How did you conduct your defense in the
you know,
MSCT case?
you know,
Did you seek any, anything from the court? Did you, in your cross-examination?
Your Lordship, I've taken my plea. I've taken my plea, Your Lordship. I'd like to take Your Lordship to the impugned judgment, Your Lordship.
No. From the TCR show us that you made the prayer, it was refused for cross-examination. As per your records, when was the evidence filed?
Claimant has filed the evidence.
We don't see from the order sheet any prayer made by the petitioner for cross-examination of the witness which was refused. Look at the record.
No, Your Lord, honors lies with the claimant, Your Lord, in a mistake claim case, not with the issuer. To prove
You
that.
see, we don't know. Your first submission was that cross-examination was not allowed. You started
my
with that.
submission was the opportunity in the sense like, Your Lordship, they have not produced documents of a postmortem to establish the cause of the death.
You forget the postmortem report. There's other documents. The evidence says the petitioner laid an evidence, whatever it is worth. You see, we take a very horrible example. The most horrible example I can give is that the petitioner produces a horoscope reading report by an astrologer. He says that this man is likely to die from a motor accident. That is his only evidence. And one day he died, and the evidence said that his horoscope says that he will die in a motor accident, and this is the death report.
Lordship, in this regard, the claimant has filed under 166 of MPA. Now the onus lies with the claimant that the deceased or the injured has suffered or the cause of the death was due to the accident. This is the onus lies with the claimant, not with the
There is
insured.
a medical certificate. It says that because of that accident, he died. A small, very small document, 5-letter, 5-line certificate by a doctor.
That can be confirmed by the postmortem, Your Lordship. The cause of the accident, not by the X-ray report. X-ray and some report is there.
I don't know.
However, Your Lordship, the discretion of the court, this is my submission, Your Lordship.
I don't know. We have medical experts everywhere. Every home you go, everybody knows how to advise for medical. If you have a sore throat, in your bar, at least 10 people will tell you what to do for a sore throat. Everybody knows medical here. The evidence was led. You were present. You did not cross-examine. You did not cross-examine.
No, they have filed only the documents, not, they have not produced a witness who have issued the documents.
No, it can't be.
They have only produced the documents. They have not produced the.
No witness was
No
examined.
witness was produced. Who have issued the certificate? They've only exhibited the documents. In your lordship, mere exhibiting of documents not suffice the stand of the contents. Lordship, this is the document of the claim. So there is, the propensity of the document has to be proved. That's my submission in respect of this.
Have you read the TCR? Have you read the TCR? No. Then you are definitely wasting our time.
No, Lordship. I have some other grounds.
I don't know whether if you don't read the TCR and start arguing on a matter, you are definitely wasting our time. You have flagged the evidence and the cross-examination by the insurer. Look at it.
I have some other grounds, Lordship.
Don't waste time. You are arguing before this court without looking at the TCR. That is the first misconduct you are doing. It's a misconduct, professional misconduct you are doing. You are telling us a statement which is not bound by the record. You are making a false statement. That is the second thing you are doing. You made two statements. Number one, an opportunity of cross-examination was not given. It's a false statement.
Your Lordship,
We'll send this matter to the Bar Council.
Your Lordship, my submission was that since the witness was not produced, who has issued the documents? I was on that line, Your Lordship. I was on that line.
You asked, you see the cross-examination you have done. You have not even questioned it. We have flagged it for you. You did not make that argument before the trial court that the doctor was not examined and therefore that evidence must be rejected. You did not even ask this, the witness, is the doctor in your list of witness? And since you have not read the TCR, you don't even know where the records are. We have told you that we have flagged. And even that, you don't have the time and energy to look at the documents which you have flagged.
Lordship, This matter was taken by the other counsel in the lower court and it was referred to me. The judge
Okay,
found it,
so what happens if the matter travels to Supreme Court, then what happens? The Supreme Court lawyers will say that we don't know what is there in the record because trial court lawyer is not there. In the High Court, that is what you say in a MEC appeal. Your conduct has to be referred to the Bar Council.
Whatever has been supplied to me, I was arguing on that point.
And you'll start arguing whatever is supplied to you. You don't even go to the records.
Take the apology for that.
That is something we never did even when first day of practice. I was not so naive even in my first day of practice when I joined the bar. I'm not here to make summons to you as to how to conduct yourself as a lawyer. If you don't know, don't touch these appeal cases before the High Court. Nobody requested you with folded hands that you must be the only person to conduct the cases.
Thank you apology for that.
No. On these two grounds only, we are dismissing your appeal. It can't be. We don't expect a lawyer to assist us without reading the TCR. If that is so difficult, don't be here. We know how to assist ourselves. How much time did it take us to find out when you made that statement? Hardly by the watch, we have taken 3 minutes to find out what is there. And you are making false statements one after the other. It's a gross misconduct. We'll refer this to the Bar Council. This can't be done. If you don't have the TCR, don't make your submissions.
Thank you apology.
No, apology won't do. This is not how you conduct. In case you may win or lose, but you have to give your heart to it. Your insurance company thinks that they have been correctly handled, and you are here before us without even reading the records. This is how you expect us to assist us? No. Sorry, we will not hear you anymore. By filing this appeal, the appellant, the United India Insurance Company Limited, has assailed the order and award dated 20 February 2019, passed by the Motor Accident Claims Tribunal, Dimapur, in MSC case number 20 of 2013, thereby awarding compensation to the extent of rupees 19,65,690 in favor of the petitioner who had made the claim on behalf of on the death of her husband, namely, husband, respond number 1A, being Borsing Teron, Borsing Teron, alias Borsing Teran Terang. Most of the respondent numbers A1 within bracket A is the claimant and is the claimant, the wife of the deceased, and respondent numbers 1 within bracket small b, TO2, 1F are the sons of the deceased, and the petition and the respondent number 1A. Next paragraph. The case before the learned tribunal is to the effect that that their predecessor in interest was a pedestrian, was knocked down by a vehicle bearing registration number AS-23, vehicle within bracket gypsy, bearing registration number AS-23-6063 on 5/10/2011, and he had expired on 19/7/2013 after being treated for the grievous injuries and fractures at Bokajan Hospital, District Hospital, Dimapur, Zion, ZION, Zion Hospital, Dimapur, Gauhati Medical College and Hospital, GNRC, Gauhati, and lastly at District Hospital, Dimapur. Next paragraph. Upon pleadings, on the basis of pleadings, the following issues were framed by the learned tribunal. Page 14, like full stop. In support of the claim, the respondent number 1B namely, Sri Verang, VERANG, Terang, TERANG, was examined as PW1. Stop. He had exhibited the following documents. Page 14, paragraph 6, pencil mark. Mm-hmm. Ten documents. First of the nature of cross-examination of the claimant witness number 1 is extracted under paragraph 8 of the impugned award. Oh no, there's a mistake. Okay. The don't say the date. I said that the the vehicle owner as well as the insurance company had cross-examined the said PW1, claimant witness number 1. And as far as the claimant number 2 is concerned, on behalf of the insurer, he said witness was cross-examined. Next one. The branch manager of the appellant company also examined himself as DW1. And he was cross-examined on behalf of the claimant. Thereafter, the tribunal had heard the matter. On behalf of the applicants, the claimants, as well as the appellants, written submissions was also filed. And the learned tribunal on appreciating the materials available on record, including the evidence tendered by both sides, decided all the issues in favor of the claimants by holding in respect of issue number 1 that the cause of accident was due to rash and negligent driving of the driver of the offending vehicle, in which the deceased received injuries in the said vehicular accident on 5/10/2011. Stop. In respect of respondent issue number 2, the tribunal took note that the postmortem was not conducted. However, based on the evidence on record, it was held that the oral evidence of the PW1 and DW1 and the documentary evidence corroborates each other to prove that the deceased died on 19/7/2013 due to injuries arising out of the vehicle accident on 5/10/2011. The issue number 3 was also decided in favor of the claimant by holding that it is immaterial to consider whether a regular case was registered or not, or whether the driver was punished. But further holding that the scope of the tribunal was only to consider whether there was an accident involving a motor vehicle and whether the person who had suffered wrong or injury due to fault of any person in connection with the use of the motor vehicle. In respect of issue number 4, the learned tribunal considered the evidence, including the service book of the deceased, and in respect of issue number 5, considering the salary and future prospects, the award to the extent of rupees 19,65,690 was awarded. Next paragraph. The learned counsel for the petitioner had urged that though the death accident took place on 5/10/2011 and the injured person expired on 19/7/2013, without producing any postmortem report, the cause of death was never established by the claimants. As per it is specifically submitted that the appellants had not been given any opportunity of cross-examining the witnesses. Full stop. In this regard, the submissions was modified by stating that the doctors were not examined by the claimant by producing them as witnesses, and therefore there is no opportunity to the appellants to cross-examine the doctors or hospitals where the deceased were treated. Next paragraph. Yes, you want to say something? Okay, no, you are standing, that's why we thought. Okay.
Just a please.
Oh, no, it's okay. I thought I was incorrectly recording something, so, okay. Next paragraph. Both sides on the submissions made by the learned counsel for the petition, for the appellants. Next paragraph. In this case, the trial court records of the tribunal does reflect that the insurer was, the appellant insurer was granted reasonable opportunity to cross-examine DW1 and, PW1 and PW2, but though the trial court record was handed over to the learned counsel for the appellant, no worthwhile cross-examination could be shown to dispute any of the exhibited documents. First, on the pointed query of the court, the learned counsel for the appellant has submitted that he has not previously consulted the trial court record. Next paragraph. It is also seen that the appellant has also tendered evidence by examining the branch manager, of the United India Insurance Company Limited, Dimapur branch as DW1. Full stop. His cross-examination is found to be extracted under paragraph 8 of the impugned opinion. Okay, we'll continue after lunch. Next panel. The claimants in the evidence of PW1 had exhibited the police report as exhibit P within P-2. Which is a copy of the accident report issued by the officer in charge, Gauhati Police Station, District Karbi Anglong. The records do not reveal that any objection was filed on the introduction of the evidence of inform of the said police report within bracket exhibit P-2. In the evidence of DW1, the DW1 has admitted that the vehicle number gypsy vehicle number AS-23-6063 was insured by the Duliajan branch of their company, which was valid from 22/9/2011 to 21/9/2012. DW1 has also admitted that the police of Gauhati Police Station had registered a case by GDE number 165 of 2011. Full stop. In the evidence of DW1, he had stated that no regular case was registered. There was no mechanical report of the vehicle, and there was no postmortem report to establish the cause of death of the deceased. And that there was no income certificate filed in support of the claim. The records also reveal that the petitioner has exhibited the incomes Do you have a copy of that income statement, Exhibit 8? You're not being able to find that.
The service record.
Service record.
Yes, Council.
That's
Exhibit B10 is the service record, Lordship.
no. Then there is something wrong. There is something wrong. Something is wrong. You have a copy of the evidence of DW1.
Yes, Lordship.
Please read in the second paragraph, middle, Exhibit 8 reflects that the deceased was drawing salary after the accident took place, and on 1/7/2012, the deceased was drawing rupees 11,300. Where is that?
This is the statement of the DW1, Lordship.
Where is the document? Exhibit 8 is not that document.
Yes, Lordship.
No, then
In the statement of the Lordship, it is statement of the PW1, the claimant. Exhibit P8 is stated to be the succession certificate only.
it's not a succession certificate.
Yes, Lordship.
It's a next of kin certificate.
Next of kin certificate. And exhibit P10 is the service record of my late father.
But then how the income was calculated? No, this matter has to be remanded back. After all this, I said, this matter would have to be remanded back. Look at this LCR.
Lordship, no objection, Lordship.
No, look at this. You must understand why you are remanding it. You see the front flag I have given. Yes. Two documents I have flagged. This is the next of kin. It's not a, it's
Next of kin.
it's not a next of kin. Look at the next one document. This is that 19,000 rupees document, which is not even exhibited. So calculation is made on the basis of document which is not exhibited.
Issued by the headmaster,
Yes,
Katrina Torbi LP School. It has not been exhibited, Lordship.
then it couldn't have been, it goes back.
Yes, Lordship.
Next paragraph. However, not same, continue, say, however, the DW1 in his evidence on affidavit in his deposition before the learned tribunal, had referred to the document relating to deceased drawing salary after the accident and referred it as exhibit EXT P-H 8 P-8. Drawing salary after the accident. And on 1/7/2012, he was drawing salary of rupees 11,300. However, in his cross-examination, the said witness has stated that he has no contradiction with regard to exhibit P8 and exhibit P10 respectively, being the succession certificate and next of kin as next of kin and service record. The next, the learned tribunal has also determined the loss of earning based on the projection regarding salary income of the deceased as rupees 19,000. However, on a perusal of the record, it is surprising that exhibit P8 is a photocopy of a certificate under the caption "to whom it may concern," signed by the Additional Deputy Commissioner, Karbi Anglong. The said statement, the said certificate merely states that the respondent numbers one A to one F are the next of kin of the deceased, late Borsing, BURSING, Terang. Most of the document which is exhibited as exhibit P10 is the service book of the deceased. Which refers to his pay fixation of rupees 11,300 as on 1/7/2012. However, as per the contents of the said photocopy of the service book, it merely contains an entry at page 61 of the TCR that the deceased had availed 1 month earned leave while office memo referred therein with effect from 8/10/2011 to 7/11/2011, which was countersigned by the sub-divisional primary education officer, Bokajan subdivision. And it contains an entry of 30 days earned leave granted to the petitioner, to the deceased, while memo referred therein with effect from 17/2/2012 to 16/3/2012. Therefore, we find that the said document within bracket exhibit P10 does not contain any entry to the effect that the deceased was continuously absent from his duty from 5/10/2011 till his death on 19/7/2013. So moreover, the learned tribunal is found to have calculated the monthly loss of income by taking into account the monthly income of rupees 11,300 with 30% addition towards future prospects. Oh, no, 19,000 was not considered, it was 11,300. Therefore, comma. On an appreciation of the materials on record, comma, in view of the entries contained in the service book showing intermittent absence of the deceased, comma, the court is of the considered opinion that the respondent numbers 1A to 1F were the claimants before the learned tribunal have failed to demonstrate that the deceased was totally incapacitated from the date of accident till his death. From the date of his accident, i.e. 5/10/2011 till his death on 19/7/2013. The claim petition at paragraph 8 of the claim form, the claim petition it has been projected that the deceased had suffered multiple nature grievous injuries and subsequently died during treatment. On the evidence of the claimant witness number 1, there's no statement by the PW1 regarding continuous bedridden condition of his father, and without referring to the dates, to the relevant dates regarding medical treatment and the period of hospitalization, all the medical documents and cash memos, all the medical documents were exhibited as Exhibit P6 and the certificate of death issued by the Department of Health Services was marked as Exhibit 9. So therefore, the court is unable to concur with the finding of the learned tribunal regarding finding that the deceased being under continuous treatment by holding that the oral evidence of PW1 and DW1 and the documentary evidence corroborates each other to prove that the deceased Bor Singh Terang, BOR, next word SING, next word Terang, TERANG, died on 19/7/2013 due to injuries arising out of vehicle accident on 5/10/2011. Full stop. In the opinion of the court, as the accident took place on 5/10/2011, comma, the learned tribunal ought to have recorded a finding as to whether in terms of the service records, when the deceased was only, had only availed intermittent leave. Comma. How far the claimant has been able to prove that the deceased was under continuous treatment for the accident. Next paragraph. As this is, essential facts have not been gone into by the learned member, comma, motor accident claims tribunal. Comma, Dimapur, comma, Nagaland. Or court is inclined to set aside the impugned order and award dated 22/2019, passed by so and so and so and so. Next paragraph. It may be mentioned that the issue regarding continuous treatment after the accident or the proximate cause of death has to be recorded by the learned tribunal by appreciating the evidence on record. And therefore, from the available documents, comma, it would not be possible for this court in exercise of appellate jurisdiction to venture into finding of fact so as to ascertain that was to render a finding on the proximate cause of death of the deceased, which arises out of an accident which occurred on 5/10/2011. This can only be proved in an by examining of witnesses and examination of the evidence on record. Therefore, the court has no other option but to remand the matter back to the said tribunal for a fresh decision in accordance with law. Next paragraph. Having regard to the nature of the claim made, comma, in the event any of the parties to the proceedings make a prayer before the learned tribunal to allow them to adduce additional evidence, or the same shall be considered by the learned tribunal in accordance with law.
Lordship, my humble prayer. In the court, lower court, in the trial court, claimant may be allowed to amend his petition if so desired.
We have given that liberty,
Yes,
even without asking.
Lordship.
Next para, the though the court has not found the any assistance from the learned counsel for the appellant, nonetheless, the matter stands remanded. Next para, the registry shall transmit back the records of the learned tribunal as expeditiously as possible. Next para, both sides, as the appellant and the respondent numbers 1A to 1F are present and represented through the learned counsel, comma, both sides are directed to appear before the member, before the learned member, comma, motor accident claims tribunal, comma, Dimapur, comma, Nagaland, on When should we fix a date for appearance to both of
Maybe the
you?
last part of this month, Lordship.
This part of the last part of the month? Okay. On 25th?
Lordship.
Okay, 25, 9, 2025. Okay. This was the
Deeply obliged.
no, it will be appeal stands partly allowed to the extent as indicated above. Leaving both parties to share their own cost.
For admission, item number 10.
Yes,
This my lord,
you're there for?
My state respondents, Lordship. For state respondents.
No, CGC? Where is CGC and this National Highway Authority?
National Highway Authority, seems they're not having their advocate here,
They're not having advocate.
no advocate. Except the Central Government Standing Council. My lord, here,
CGC is not coming. You have told CGC. Whom did you tell?
I spoken with them,
Huh?
I've spoken with them,
Whom?
Central Government,
Huh?
Government Council, Central Government Standing Council.
No, there must be some name of the CGC.
Younger,
Huh?
younger,
Younger.
yeah.
Is CGC.
And my lord, we have served the register post, through the register post only, we sent it to a first respondent, that is board, and the National Highway Authority of India on the May 27th, 5, 2025, it is on postal tracking report, as per the postal tracking report, they have already received.
Okay, where is the notification of land acquisition?
I beg your pardon, my lord.
Where is the notification of land acquisition?
There's no gazette notification.
There's no gazette
There's no
notification.
gazette notification. Right from the beginning, so we have been fighting for that.
And where is the notification of the chief secretary saying that it is not covered? Where is that?
No, even chief secretaries, they have not issued any gazette notifications.
No. You are saying that the chief secretary has issued a notice that in July 2024, that all projects sanctioned between November 2018 and November 23 are not covered. Where is that?
Is there in report?
Hmm?
I know today I could brought my report because I was thinking that whether the central government and respondent number 2, NHI will file the counter affidavit or not. For that only.
Okay. The learned counsel for the petitioner as well as the learned government advocate are present. Next para. The matter was adjourned at the first call by requiring the learned counsel for the petitioner to inform the CGC to enter appearance in the matter on behalf of the respondent number 1, being the Union of India, represented through the Secretary, Ministry of Road Transport and Highways and Transport Bhavan. Full stop. However, it is reported that Mr. What is the name? CGC?
Yangarwati Lordship.
Yangarwati.
Yangarwati Lordship.
So, Mr. Yangarwati, CGC has declined to appear before the court as the NHAI has a different standing counsel. Next para. We take note of the fact that as per the office note dated 30/5/2025, the notice on respondent numbers 1 and 2 is accepted to be duly served in view of the track record report. You are directed to take dusty service. Have you taken?
Yes, my lord, I have already taken justice service on the service in June. And I have filed affidavit for that also. And this is the copy I have appealed from CGSC. They have already received it.
No, you have to take first service. This is not the way to serve. You see, you were asked to give dusty service to respondent number 1 and 2. You have gone and given it to through the central government standing council. This can't happen. That is not dusty service. Next. It is noted that by order dated 24/6/2025, this court had directed the petitioners to take steps for service of notice on respondent number 1 and 2 through the Central Government Council. Upon service of notice to the Central Government Council, an affidavit of service has been filed on 4/8/2025, indicating that notice was served on the on Mr. on the CGC. Next, taking note of the submissions made at the bar that the National Highway Authority of India has a separate set of counsel. Neither is it me. How it is noticed, whether as it may, it is noticed that the National Highway Authority of India, by a letter number, this is the number, by letter number so and so, dated 2/7/2025, appear to be aware of the pendency of the present date petition. And by the said letter, the executive director, NHIDCL, Kohima, was directed to take steps. Therefore, as it is found that the notice of this proceeding has been served on the learned CGC, as well as the notice is seen to be duly served by the consignment track report, of which the office had taken note of on 35/2025, as well as statement made by the learned counsel for the petitioner that the listing of the matter today was also informed to the learned CGC, court is inclined to hold that the notice on respondent numbers 1 and 2 is duly served. So none appears on call for the said respondents. Next para on the stop accordingly. Yaganpati spelling is YANGER. Next word is Vati, WATI. So, accordingly. On the prayer made by the counsel for the petitioner, the matter is adjourned today. List after
4 weeks, my lord.
list after 4 weeks. You don't have to take steps. You have accepted due service. You take back your letter. You don't have to take first steps. You have accepted the service.
That's your plan.
For hearing, item number 28.
Yes.
Lordship, the petitioner hearing is before the Supreme Court, praying for the less strong heirs in his salary. Lordship, while he was serving as an inspector in this commissioner of police in Dimapur, he came to know that there was a less strong heir salary. While he was working in this under the commandant 14 IRB Kifri. Lordship, I may be relying on my petition, page 6. The whole facts and in my prayer, I would like to state, as I stated in my paragraph, page 6 of my petition. I may be allowed to read. That the petitioner was serving.
Don't read,
as-
just tell us what the facts are. Don't
Lordship,
read.
Yes. So as I say, while the petitioner was serving as sub-inspector under the establishment of Commandant 14 NAIR, Kiburi, Nagaland, the petitioner was given less salary for the period during the period 1/07/2016 to 1/11/2018. That is 29 months. Less salary was given to him, and then that comes around 4,65,818. So in order to justify that one, I'll come to in a very brief way. Lordship.
What does
I-
what does the state say?
Lordship, I'll come to that. I'll try to finish up in this short time. So I'll just wanted to apprise before the score that page 20 of my petition. This is the annexure 5. How I have calculated the less than salary. This is the annexure 5, page 20 of my petition. Then Lordship, this chart was made basing on my arrow, that is the following page 21. That is annexure 6. This is how I have prepared the calculated the less than error. And then that was based on the arrow of my bay, that is annexure 6. Now what I'm saying is, Lordship, this proof, if the Lordship may kindly turn to my bank statement, that is page 23, annexure starting from annexure 7 series.
Where is your salary slip?
So Lordship, this is page 22 is my record of service where I my
No,
scale
no,
of pay.
every time you get salary, you get a salary slip. Where is that?
Lordship, my salary is given in a common way, in an arrow, maintaining by arrow. So Lordship, that in order to justify my submission, Lordship, if your Lordship kindly turn to my this bank statement, how my pay was given to. Annexure 7 series.
No, bank statement doesn't give a clear picture. You
Yes.
see, if you go and check my bank account, you will not get the clear picture of what my salary is. You take my court master here. If you look at his bank statement, you will
That
not
is why-
find what his salary is.
That is why I have basic.
That is not how salary is calculated. Salary is calculated on the basis of certain accruals and the deductions which are made.
Yes, that is why this is the page 1, annexure 6 is my how I'm getting my salary. This is the total amount.
Page?
Page 21, annexure 6. This is my A roll for the month of July 2016 up to November 2020.
So
Yes.
show me this first statement here, July 2016. Where is your bank account?
So, Lordship, page 23.
Page 23.
Yes, page 23, the first line.
Yes,
Yes, so first
July to November.
2016.
Yes.
So my what you call salary has been credited 32,341. So if you kindly refer that one in this my calculation, annexure 5, page 20, I'm supposed to get after deduction 35722.
Yes.
But I have received only 32341. So less thrown is 3381. That is my calculation. And then this calculation was made, as I say, basing on the page.
No, in the month of July,
Yes,
you will get salary for the month of June.
yes.
So don't show 32341. You'll have to, for the showing us July 16 salary, you'll have to show us August 2016 entry. In
Yes.
August, what do you get?
And then Lordship, in order to show more illustration, Lordship may kindly turn to my serial number 18, page 20, serial 18, 1/12/2017. Page 20, just to show some illustration, because this is a numerical thing, so I want to make a comparison, how I have given the salary and then the less. So this serial number 18, this indicates of 1/12/2017, that is December. So if your Lordship may kindly to my, what you call, bank statement, how much I have received. Oh, 17, page 24. 3rd July 2017. Sorry, Lordship. Lordship, it is. It's December. Yes. Page 25.
Okay.
Page 25, 5 December.
Yes, and what is the government saying?
Here, in order to save the court's time, Your Lordship, here, this is a clear disputed facts, and on last occasion, I have been directed to file a report, Your Lordship. So I filed a report in the form of the affidavit, Your Lordship. By this court's order, Your Lordship. If I may be allowed to read, Your Lordship.
To submit a report
Yes, Your
in
Lordship.
relation to representation.
Yes, Your Lordship.
Yes, what is that report?
The affidavit is filed on 4th of July, 2025, Your Lordship.
4th of July,
No, 24th, 24.
24th of July.
Yes, Your Lordship.
You file an affidavit.
Yes, Your Lordship, enclosing the report as directed by the court, Your Lordship. So this, by this report, there are some calculations given, which has been prepared by accounts personnel, Your Lordship. So as per these instructions, Your Lordship, there is no less drawn salary, Your Lordship. In fact, the petitioner has there's excess drawn, Your Lordship.
No, you come to this, what the learned counsel for the petitioner is showing.
Yes, Your Lordship.
This is a roll he's showing at page 21.
Your Lordship, if I may, Your Lordship, in response to this, I had already filed an affidavit countering the claim, Your Lordship, enclosing the arrow of all the.
Where is that?
It's an affidavit file which was filed on 7 June 2024.
7 June.
Yes, Your Lordship. On the last occasion also, this matter was heard, but the court referred a report because there was disputed facts.
7th?
It was filed on 7 June 2024.
Yes.
So I have filed the whole A roll, Your Lordship, acquaintance roll.
You just show me this July 16 to November 16, page 21 of the petition. Show any of the entries there.
July 16, right?
Page 21 of the writ petition.
Yes, Your Lordship. So the A roll in respect of that is page 36 of my affidavit.
36.
Yes, Your Lordship. Page 36 of my affidavit, which was counter affidavit.
Yes, 36.
Yes, Your Lordship.
36th month is July 16.
Yes, Your Lordship, July 16.
Yes.
So the
14,630. Then DA is 19. No, this is again an entry because this is 21 is your document. DA, you are adding 19,000 there in page 21. Here you are adding up 17,411.
that is the document. So our documents are conflicting here. There's some disputed facts, Your Lordship. Because of that, Your Lordship, I was asked to file a report. And this report clearly shows that there was no less drawn salary. Your Lordship.
No. First of all, whatever you say, first of all, you have to deny this document.
Right.
Unless you deny this, why should I look at the report? Although there is a judicial order.
Deny the document, Your Lordship.
Where is that?
Lordship.
Lordship, paragraph 5, Your Lordship.
But what is the difficulty in producing the salary slip? You see, this page 36, who has typed this? Who has typed this page 36?
Acquaintance role, Your Lordship. This is maintained by the department, Lord, for all the employees, Your Lordship. And basing on this, Your Lordship, we have made the submission, Your Lordship. This is the acquaintance role with deduction fees. For all the employees, Your Lordship, we maintain a A role, Your Lordship. In fact, even in the representation, the petitioner had sought for A role, Your Lordship. So the calculations, the submission is based on this A role, Your Lordship. And the petitioner is also saying that his calculation is based on the A role, Your Lordship. But both our calculations are different, Your Lordship.
No, you allow him to to access this in your office. Let him go and satisfy for himself that this is the acquaintance role.
So, Lordship, that's why, Your Lordship, direction may be given, Your Lordship.
Lordship, may I have
So
some short?
petitioner may be approach the department, Your Lordship, because
Yes.
these are clear disputed facts.
What do you to say?
Lordship, may I have a short submission on this line? This submission, this counter was filed initially by the state, and then this indicates TA error. This is TA error. Whereas I'm asking for less drawn salary.
Don't tell that. Don't tell that.
And then Lordship,
You see, you come to it. That's why when we are looking at the document, we are searching for every entry. Page 21,
yes,
DA is 19552.
yes,
And in this, the DA is 17411.
Correct.
So there's a difference of 2000.
right.
Then-
That is why I'm saying that you have given me less. Now,
No.
now, Lordship, may I have further submission? Basing on the some clarity, the court, this honorable court has sought some clarification for calculation. Now, the second affidavit, tier 5. So I'll come to that in a very short and very brief way. Dear affidavit, the second subsequent affidavit, they are saying that I have drawn excess starting from 2010 to 16. Whereas in my petition, I'm claiming for 2006 from 16 to 18. So, and then in that 2016 to 18, they are saying that I have given less in the remark. Lordship may kindly see the reply, the subsequent reply. And then the remark, page 11. This page 11. Page 11 of the last counter affidavit filed by the state.
Last affidavit 10 July,
Yes,
20 August. There's one 20 August.
this is Lordship, the last affidavit filed by the state. So at page.
Which one?
11
Which one? One is 20 August. That is the last one. Okay.
I don't know about the date, but yeah,
Okay.
yes. So.
Which
the-
paragraph?
Yeah, the last remark. The last remark, I may be allowed to read. Remarks, number 1, excess pay drawn with effect from
There is
7,
no-
9, page 11. Page 11 of the,
Wait, annexure.
and that is annexure. Got it, Lordship?
Last page.
Yes, last page 11, page 11. Not last page, but page 11. Page 11. Page 11.
Page 11. Yes.
How would he have made the remark? Number 1, excess pay drawn with effect from 7/9/2010 to 36/2016 is to be recovered. Second, heir of less pay drawn with effect from 1/7/2016 to 39/2018 is to be prepared. Thereby meaning, I have drawn excess from the year 2010 to 16 and less drawn from 16 to 18. Meaning, they are also admitting that I was given less pay during the period of 16 and 18. And in this instant petition, Lordship may kindly note this one. I have prepared a specific submission on the
Your
less-
submissions doesn't take us anywhere.
Lordship,
It doesn't take us anywhere. Page 11 you are showing us. You look at the last column which we are reading. Consequent upon pay rectification, the person was drawing less salary as follows. Basic pay as on 1/7/2016,
Yes.
basic pay as on so-and-so,
yes.
DNI for so-and-so, and therefore end is basic pay as on 1/10/18 and basic pay as on 1/10/18. So this is of 18.
Lordship, so what I'm trying to say is that the instead of replying to the 16 and 18, the state has again brought some irrelevant.
Let them take whatever they want.
Oh,
But
Lordship.
we are reading that document, and this document has a clear difference of the same month, the calculation of the DA. So your calculation is 2,000 more. It has to have a cascading effect here.
Lordship, so Lordship, my humble submission, as I have already submitted my representation, so let them.
No representation business. We are hearing the matter, we'll dispose it of.
Lordship.
We don't want any representation. What representation they will say beyond this document which they have prepared?
So my humble submission, Lordship, is that, Lordship, as I pray. See, this is the second reply they have given. In the earlier, they have denied. They have denied that no, there is no less drawn error. And then in the second subsequent, they are saying that yes, for the period 16 you have less drawn. So there two affidavit, it's contradict each other, Lordship.
No, doesn't.
Lordship, that is why my humble submission is that I have prepared this calculation basing on that error which was taken up from the office. So let my petition be considered.
We are considering it. That's why we are asking a question.
Lordship.
You see, we are again giving a chance. Page 11 says the opening date and end date is the opening date is 1/7/16, end date is 1/10/2018. 1/10/2018 includes page 21, column number 1, which is July 2018 to November 2016 to 2016. And then the end date here is November 2018. So this is between this period, what you are showing, they are finding a fault of some amount.
Lordship.
Correct. 2010 to 16. So this is one part. Then in respect of these calculations, they have now stated in their affidavit a copy of the acquaintance roll, which they say is the acquaintance roll at page 36, where they have demonstrated that the DA was 17,411. So that makes the calculation mistake in your document. So this you have got from where? And HS6 is got from where?
Lordship, in that case, may I have a submission that the state has a treasury and an account department who is looking after all those pay slip, this and the skill you used to verify. So see, I would like to bring to the notice of the court that my petitioner has all the time requested the state respondent to consider and then apprise about delay this and that. So they are very much concerned about my this resignation. And then all the time they are saying one after another. So as I have stated in my prayer, that this honorable court, if things fit so, by passing another order, by directing the rightful this department to verify, because this requires some technical calculation, this and that.
No, it doesn't. It doesn't. That's why you are trying to point it out to you. You see, in this, so far as I am concerned in the bench, I do not want to call for these reports. These reports have been called for, affidavits have been filed. Then without doing the homework of making the calculation, I would remand the matter for a fresh consideration or representation. That is something I am not doing.
Not sure.
We are considering the document and the materials available with us, and we'll do the calculation.
Lordship, that is why, Lordship, I have clearly stated in my of my statement, bank statement, where I have indicated though there may be some this technical error of this date, but the amount which I have indicated is clearly reflected in my bank statement, how my salary has been credited. And then, as Lordship had kindly pointed out, my calculation, error, and then this calculation has never been a part of the counter affidavit, rejecting that the calculation is wrong. They are only saying that there is no liability, and then they are submitting this DA error, this and that.
Still there, which- Screen पे भी आ रहा है। ये नहीं चाहिए मतलब। ये वाला चाहिए सिर्फ। हेलो। Mr. Hope, do you have anything more to say, both of you? You have anything more to say?
Lordship, that's all. My sports appreciated.
With regard to this DA, the petitioner has brought his own calculation at it's page 21, Your Lordship. As per the order annexed, Your Lordship, for the month of July 2016, the DA was 119%, Your Lordship, and which is rightly reflected in page 13 of my
21 of the writ petition.
yes, Your Lordship. Your Lordship, it's got it, page 21 of the writ petition.
Yes.
Yes, Your Lordship, page 21, and if you compare it to page 13 of my additional affidavit, Your Lordship, which was filed on 27 or 24 July. Page 13, Your Lordship.
13.
Yes, Your Lordship. So if in the first column, Your Lordship, period 1st June 2016 to 30th November 2016, Your Lordship. In the BP, Your Lordship, pay band is 15,500. And Your Lordship, in that column, the same column itself, 1st July 2016 to 30/11/2016, DA is
1st July 2016.
Yeah, us.
Which entry is that?
Your Lordship, are you referring to page 13?
1-3.
Column 1, page 13.
1-3.
Yes, 1-3.
Column 1.
Yes, column 1.
Is period 1-1-17
Yes.
to 31-5-17.
31/11/16.
No. Page 13 is not that.
I think I'm referring to additional affidavit file on 24/7/2005.
24/7.
2005. Additional affidavit.
Page 13, yes.
In that first column, serial number period, Your Lordship, from 1st July 2016 to 30th November 2016, the DA percentage was 132. So, but the petitioner was given only in the petitioners, in the column due, the pay band is 15,500, and the petition in the next one, less drawn, it's 14,630, Your Lordship. So if we go by the petitioner's calculation, it's in page 21, Your Lordship, DA is 19,552. So I don't know where he got this calculation, Your Lordship. It should be 19,312. If we 132%.
2460. Here is more. Here it indicates more.
That's what you are due. So if he wants to reject that, Your Lordship. And even in my affidavit also, Your Lordship, the DA. So the petitioner may be asked to justify as to where this calculation is coming from in his petition, Your Lordship, 21, page number 21. And to substantiate that point that in the month of July 2016, the DA was 132%. It's in my counter affidavit, page 9. Counter affidavit was filed on 7 June 2024.
Page,
Page 9, annexure A1. The office memorandum giving 132% DA to the government employees, Your Lordship, the page 9. So the petitioner may also be. This given is all calculation, Your Lordship, but our calculation is based on the OEM, Your Lordship, giving.
You're Mr. S. Temjen.
Lordship.
Heard Mr. S. Temjen on the counsel for the petitioner. Also heard.
No, in Holly.
In our field, and your government advocate, appearing for the all the respondents.
Yes, Your Lordship, compares.
By filing this writ petition under Article 226 of the Constitution of India, comma, the petitioner has raised a grievance that he has, comma, on examining his pay entitlements, has detected less drawing of his salary for last 29 months to the extent of rupees 4,65,818. Full stop. It is projected that the petitioner has already superannuated from service on 30/6/2022. Next paragraph. The case of the petitioner, comma, in brief, comma, is that he was initially appointed as a police constable on 19/6/1986 as under IC number 1244. Stop. Thereafter, his service was regularized and he was also promoted to a higher level of post. Stop. After rendering 35 years of service, comma, the petitioner was superannuated from service on 36/2021, followed by a release order dated 22/9/2022. Stop. While serving as sub-inspector under the establishment of commandant, comma, 14th NAP within bracket IR bracket close, Kiphire, KIPHIRE, Nagaland. He was given less salary for the period between 1/7/2016 and 1/11/2018 for a period of 29 months, amounting to rupees 4,65,818, stated above. Stop. In order to show the less drawing of salary, comma, the petitioner has relied on the acquaintance roll for the period of July 2016 to November 2018, as well as his bank statement to show that the amount shown in the acquaintance roll within bracket annexure 6, Roman 6, bracket close, is not the amount which is entered into his bank account. Full stop. Accordingly, the learned counsel for the petitioner has submitted that though the petitioner had made representations to the Director General of Police, Kohima, as well as to the other to the Commissioner of Police, Dimapur. To the Dimapur also, Commissioner of Police also gave representation. And the authorities had communicated to look into the matter, but no prompt action has been taken on behalf of the state respondents to examine the claim of the matter, claim of the petitioner, and to make payment of the less drawn salary for 29 months.
I may, Your Lordship, the representation is not with regard to claiming of less drawn error, Your Lordship. He was just praying for submission of error or furnishing of error, Your Lordship. On both occasions, Your Lordship, on 12/5/2022 and 29/6/2022, Your Lordship. If you go through the representation, Your Lordship. They've just prayed for error for less.
Which page?
Page 28 and 29 of the petition, Your Lordship.
28 and 29.
Your Lordship.
Lordship,
And this error we have submitted in the form of an affidavit, Your Lordship, and it's before Your Lordship.
Lordship, the representation may not be explained in a detail, but it indicates the following page, annexure 10. It is clearly shown. Application, prayer for submission of.
No, that's okay, but I must write the correct thing in my order.
Yes,
There's strong error. There was some,
but it's submission of error.
It's okay, we are not saying any adverse to you. For that, we are not drawing any adverse remark against you, but I must make the order straight.
Lordship. And then in the body of.
Had requested the Director General of Police as well as the Home Commissioner of the state of Nagaland to provide him with a copy of acquaintance roll or less drawn salary oblique aerial from 9/3/2015 to 5/12/2018. But no action has been taken by the said respondents. And accordingly, the present writ petition has been filed and has been filed with a prayer for issuance of a direction upon the respondent29 to consider the representation of the petitioner to withdraw the less drawn salary arrears for the last 29 months within a period of 2 months after rectification. Next paragraph. The learned counsel for the petitioner has submitted that the state respondents number 1 to 5 have changed their stand had filed an affidavit in opposition on 10/6/2024, and the stand taken therein was changed when the said respondents had filed their subsequent affidavit on 23/7/2025.
Lordship, as per the court's order, 25/2025.
Hmm?
25/2025. This was filed as per the court's order.
No, whatever it's the affidavit, whoever order you have filed, but it's an affidavit. Full stop. It is submitted that in the affidavit which was filed on 10/6/2024, the petitioner has given a statement regarding the acquaintance regarding has given has produced a copy of acquaintance roll with deduction list in respect of the petitioner from the month of July 2016 to November 2018. But in the subsequent affidavit filed on 23/7/2025, the state respondents have taken a stand that the petitioner has drawn excess salary for the period from 1/12/2010 to 1/12/2013 and 27/5/2014 to 1/12/2015. And they are also reflecting the less drawn pay of the petitioner for the period between 1/7/2016 to 1/10/2018. Full stop. Accordingly, it is submitted that the authorities should consider and dispose of the representation of the petitioner and to provide the complete details of the less drawn salary of the petitioner and to make payment of the same to the petitioner. Anything on facts which I have left out? Anything on facts which I have left out?
No.
Okay. Next, Prada.
Lordship, my short submission, the air excess zone shown by then, it start from zone 10 to 16. So in my position, this is not a subject matter, according to me, Lordship. And then this pay was given fixed by them, not by me. And then I'm asking only the less zone air starting from 1/7/2016 to 18.
Okay.
Lordship.
So it is further submitted that in the calculation sheet, comma, the respondent authorities have made calculation of excess pay drawn from 7/9/2010 to 1/12/2013 and from 27/5/2014 to 1/12/2015, which is beyond the claim made by the period of claim which is made by the petitioner. And in his writ petition, the only grievance of the petitioner is regarding the less drawn salary, partly of which is admitted in Annexure 3 of the affidavit dated affidavit filed on 23/7/2025. Next one. Our contract, the learned government advocate submitted that the pursuant to the notification and the office memorandum dated 10/11/2016 and corrigendum dated 11/11/2016. The issued by the finance department, the employees of the state were granted tierless allowance for employees drawing pay under ROP rules, of which the first installment was with effect from 1/1/2016. Second installment was with effect from 1/7/2016. And the increase was increase of dearless allowance was at the rate of 6% with effect from 1/1/2016. From the existing rate of 119% TO2, 125% of the pay in the pay band, including grade pay. Which is applicable to the petitioner. And for the second installment, with effect from 1/7/2016, the increase of dearness allowance was 5% with effect from 1/7/2016, from the existing rate of 125% to 130%. So, however, by the corrigendum, the increase was made to 7% with effect from 1/7/2016, from the existing 125% to 132% in the pay band, including grade pay, in respect of the rate pay of the petitioner. First of all, accordingly, comma, it is submitted that in the affidavit filed on 10/6/2024, comma, separate statements have been given, have been annexed with regard to the area DA statement, as well as with regard to the acquaintance role with deduction list in respect of the petitioner. Accordingly, it is submitted that the entries made in the acquaintance roll, which is produced by the respondents, do not tally with the entries made in respect of the statement which is acquaintance roll statement, which is annexed to the writ petition at page 21 of the writ petition. Next paragraph. The learned government advocate has further submitted that the second affidavit was filed pursuant to a direction issued by this court on 25/2025. Next paragraph. Consideration of the materials available on record being the writ petition, affidavit in opposition filed by the state respondents on 10/6/2024, affidavit in reply filed by the petitioner on additional affidavit filed by the state on 23/7/2025, and the affidavit in reply filed by the petitioner on 28/2024. Next paragraph. We are making a statement that we are trying to reproduce this page 36 onwards in the order, but if for some reason, technical reason, it cannot be scanned, then that will not be there. Correct? In the second affidavit filed by the state, this page 36 onwards is the acquaintance roll. If we can scan it and made a part of the order, we will do it. Otherwise, that will not be there. Correct?
Your Lordship, it's completely out of topic, but I seek your Lord's indulgence, Your Lordship. Though we've made a statement that there is less drawn area on that particular month which the petitioner had claimed, the amount is also different, Your Lordship. The claim that they're making and the amount that we've calculated, Your Lordship, that may also be included. So this is.
We will do it. How to write the order, leave it to us. But we are only trying to say that page 36 to this acquaintance rules is at up to page 64. If we can scan it, then we'll have it in the order. Otherwise, it will not be there. Correct? Or can you ask if your authorities have a scanned copy with them? If they can transmit it, it will be very easier for us.
I can make an endeavor if they can
If they have it, can give it to the court master tomorrow.
Tomorrow. Your lordship, since this is from Kipre, I don't know whether I can get it by tomorrow.
Just ask them,
Yes, I'll make an endeavor.
because I can't withhold the order forever.
Yes, so much.
Correct. Next problem. From the contents of the acquaintance roll, which is annexed to the writ petition at page 21, within bracket annexure 6, and the copy of acquaintance roll, which is filed by the respondent numbers 1 to 5 in their affidavit filed on 10/6/2024, clearly indicates a mismatch of the amount covered by the column regarding column of DNS allowance and DNS allowance only full stop. The amount of DNS allowance reflected in the annexure to the writ petition is shown as rupees 19,552 for the period from July 2016 to November 2016, comma, but in annexure G1, annexed to the affidavit of the state, comma, the amount of DNS allowance is shown as 119%. And quantified at rupees 17411 for the period from July 2016 to November 2018. Moreover, in the acquaintance roll annexed by the state, which is authenticated by the commandant, 14th NAP within bracket IR bracket close battalion, Ozeku, OKHEZUNG, okay, Zoom, comma, Kipire, KIPHIRE, comma, one of the column also reflects other deductions, which is rupees 1481, 1711, 4681, 1281, and 1481 respectively for the months of July 2016 to November 2016, which is on account of battalion fund, maintenance fund, NPRIS, S of the REV, canteen, NGO mess, cash in hand, school, Tithes, Tithes, Tithes. Which is not available in the document annexed by the petitioner. Full stop. The similar rate difference for the DNR's allowance also appears in respect of the acquaintance roll for the month of January 2018, which in the document annexed by the petitioner, it is shown as rupees 23,915. And is reflected as rupees 12730. Oh, sorry, 21587 at the rate of 139% for the month of January 2018. Full stop. Next paragraph. The statement or the acquaintance roll statement of the annexed by the petitioner as well as those annexed by the state is introduced here in below. If this comes, then otherwise delete that. Next paragraph. It may further be mentioned that the statement of acquaintance roll, which is available in the affidavit filed by the state respondents on 10/6/2024, is being a part of the said affidavit is also available with the learned counsel for the petitioner. Next paragraph. Therefore, insofar as the claim of the petitioners regarding less drawn salary is concerned, the same appears to be on account of two entries in the acquaintance roll, which is annexed by the petitioner, so far as the amount towards DA had the DNS allowance and the sum of other deductions are concerned. Full stop. The said document being annexed by the state respondents in their affidavit in opposition which is found to be authenticated by the commandant, 14th NAP within bracket IR, bracket close battalion. Okzung, OKHEZUNG, Kipire, KIPHIRE. Cannot be disbelieved. Full stop. The petitioner has not been able to demonstrate that the calculation of DNS allowance, which is projected by the respondents, are incorrect in any manner. Full stop. However, if the rate of DNS allowance as projected by the state is calculated, it does not match with the rate of DNS allowance as reflected in Annexure Roman 6, page 21 of the writ petition. And the deductions which are reflected in the Annexure G series, so the affidavit filed by the state on 10/6/2024 is not reflected in the calculation sheet of the petitioner. Full stop. There's nothing on record to show that the calculation of other deductions, which is reflected in the affidavit of the state, is incorrect or manufactured, or that those deductions could not have been made by the state respondents. Full stop. Next, under such circumstances, it's not found to be a fit case for sending the matter back to the concerned authorities to redo the calculation and to dispose of the representation submitted by the petitioner. Full stop. Next, the state respondents have been able to demonstrate that the pay which has been credited to the bank account of the petitioner is in accordance with the acquaintance rule prepared by the competent authorities. Next, madam. Resulting, this petition fails and the same is dismissed. Next, the learned counsel with the petitioner submitted that now in the affidavit filed by the state, the state respondents are also seeking recovery of amount excess paid. Full stop. In this regard, although there is no prayer in the writ petition, but in view of the decision of the Supreme Court of India in the case of Rafiq Masih, just found that out, Rafiq Masih. It would be open to the petitioner to respond to the respond to action against action initiated by the state for recovery of the amount due if allegedly found due from him. To stop with the aforesaid observations, Mr. Patient stands dismissed.
For hearing, item number 29.
Yes.
Please, John.
Lordship, in this petition, the applicant is praying for the direction.
Family pension. What was your husband doing?
Lordship,
What was your husband doing?
Lordship, the petitioner is unmarried, disabled daughter of the deceased employee. And the petitioner.
What is the position in the state of Nagaland? Two marriages are permissible.
Lordship,
Has the second marriage being registered before the?
The pensioner's daughter is before the court, your lordship. The pensioner's daughter is a disabled daughter. And they're seeking, since her name was not included in the PPO book during the lifetime of the pensioner, the petitioner is approaching the court. But in my affidavit, your lordship, there's an office memorandum. This affidavit was filed on 15/5/2025.
What does it say?
There's an office memorandum, your lordship. Have you found it, your lordship?
In July 15.
Yes, your lordship, 15.
Yes.
No, 15 May, 15/5/2025.
15/5. Which page is that?
Page 12, your lordship.
Page
Page 12.
12.
Yes, your lordship. If I may be allowed to read, your lordship.
Page 12 is 13 July 15.
Oh, your lordship, I thought you were referring the affidavit. Yes, yes.
No,
Your
no.
lordship, I'm sorry, your lordship. So, if I may be allowed to read the relevant paragraph, your lordship. This is the OM regard to the speedy disposal of pension and other retirement benefit. So, your lordship, I would like to read from 1 to 3rd paragraph, your lordship.
It shall not be allowed.
No, your lordship, it can be allowed, but there are certain procedures, your lordship.
Okay.
So, I may be allowed to read the relevant paragraph, your lordship.
Yes.
On the guidelines specified in the aforementioned office memorandum was supposed to avoid inclusion of the name of second wife and children as nominee after the death of the pensioner in respect of settled cases. However, it is observed that many departments, without properly verifying the genuineness of the case in accordance with the guidelines issued in the office memorandum dated 4/8/12, have been simply forwarding the petitions to Accountant General's Office for extension of pensionary benefit. Therefore, it is hereby reiterated that inclusion, change of name, which shall also include post-retirement spouse and children for the purpose of family pension after the death of the pensioner in respect of settled case, which is in this case, your lordship, the pensioner has died and it's a settled case, shall not be allowed without proper inquiry by the Deputy Commissioner of the district. Any alteration, addition in the size of the family should be immediately brought to the notice of the head office in the prescribed format for onward submission to Accountant General's Office while the pensioner is still alive. So, your lordship, on the last occasion, I had brought this before this court, and this court had directed me to get some instructions, your lordship. Because, your lordship, for verification.
How can this not possible? You are reading this. Any alteration, addition in the size of family should be brought to the notice of so and so while the pensioner is still alive. So he's not there.
Your lordship,
Now on the 3 lines above. So therefore, for the purpose of after death shall not be allowed without proper inquiry by the Deputy Commissioner. So only that part.
Yes, only that part shall not be allowed without proper inquiry. So, your lordship, in this case, the petitioner resides in Senapati, Manipur. So, on last occasion, by order dated 25th September 2020. Your lordship, I'm sorry, on 1st of August 2025, your lordship, the court had directed me to receive instructions since the petitioner is a resident of Senapati, Manipur, whether the verification has to be verification has to be done by the Deputy Commissioner Senapati or the Deputy Commissioner Kohima. So I have received an instruction saying that the verification, your lordship, if I may be able to place that instruction, your lordship. Here now, the inclusion is only possible after verification by the Deputy Commissioner.
Which Deputy Commissioner?
The petitioner has to approach the Deputy Commissioner Senapati of Manipur. And if this verification report is submitted, Your Lordship, the department will duly take steps, Your Lordship, after this.
This is something we may not do. You see, the reason is, where is that pension payment order?
Your Honor, it's in page 46 and next year 21.
Page 46.
Your Honor. This is the RTR reply and the next page is the pension. Your Honor, this is the register maintained by the AG office, Your Honor. Your Honor, the PPO belonging to the petitioner, the petitioner's mother has been lost, Your Honor. Misplaced and could not be found.
Petitioner?
The PPO, which is in possession of the petitioner's mother, has been misplaced and could not be found, Your Honor. As such, we made an RTI application before the
No,
AG office.
46, I have to say the office has issued pension in respect of Srimati S. Nisha, wife of so-and-so, holder of PPO. So therefore, it has been issued in the name of late Srimati S. Nisar,
Your Honor,
correct?
Your Honor.
So any inquiry made must be in presence of Miss S. Miss S. What is the name? Miss
Nisa.
S. Nisa.
As Nisa.
S. Nisa is not a respondent here.
As Nisa is my late mother, Your Honor, Lordship.
Your mother died.
My mother died. My father served in the Nagaland State Transport, Your Honor, and died. After the death of my mother, PPO was issued in favor of my mother.
Okay, then make an inquiry there as required.
Your Lordship,
Second,
Lordship, may I?
yes.
Regarding the instruction submitted today by the learned government advocate regarding point number 2, Lordship. Furnish fresh medical certificate from the district medical board, Sanapati, clearly certifying the medical certificate. Your Honor, I have already submitted the medical certificate, I mean, the disability certificate, Lordship.
No, but that in the investigation has to be done as per the requirement.
Your
You have to
Honor,
get-
I've also annexed the disability certificate in.
No, disability certificate is one issue. But the second is also with regard to the investigation report. That is more important. Yes, you wanted to say something?
Lordship.
Okay.
This certificate has been issued with authority by the authority, Lordship. State medical board for issuing of disability certificate. After the prior to Disability Act of 2015, Your Honor.
Don't take us to that act. We are not on that. You have been hearing us.
Lordship, I'm saying that if I approach the medical board, then I have to obtain the disability certificate again. And the medical board approved by the state government of Manipur has been already issued to me.
Here it says two things. Number one, you should go to the Senapati district and get a medical certificate from there. And also to go to this Senapati district, deputy commissioner, to get the genuineness of the family pension being initiated after the delay. For both things, you have to go there. That means the state government is not accepting their certificate.
Lordship, point number 1, I don't have anything to say, but regarding the point number 2, I have already obtained the medical certificate that I'm disabled.
they want a fresh medical certificate. This was
But they say that it has to be from the district from which you belong.
This was obtained in the year 2008, Your Lordship. So
Lordship.
they want a fresh.
Lordship, my humble submission. Until and unless the certificate has been nullified or cancelled, my apprehension is that whether the medical board will issue me a fresh certificate or not.
If that is the requirement, you have to give it.
This certificate has been issued authority with authority lordship.
No, that we don't know. If there's a requirement which requires that, you'll have to challenge it or follow it. You can easily lay a challenge on it on the ground of Disabilities Act. But if they say that this is the requirement
Lordship.
under their memorandum, you have to comply with it. We can't say no.
Lordship, with my limited understanding, my humble submission, Lordship.
No, we don't say you are wrong, but you'll have to challenge that notification. Without a challenge, we can't make an observation with regard to this. You can amend your writ petition and lay a challenge to that second requirement.
Lordship, this certificate was issued during the year 2009, and the Rights of Person with Disability Act was replaced the PWD Act of only in the year 2016, Lordship. So my humble submission is that this certificate has the validity.
You have to challenge it. There's not a challenge. In your writ petition, you amend your writ petition, then we will also make that observation. If it is not there, we can't just pass any order. For the time being, this is the requirement of the OM. We can't say no. It's not a challenge. We have not given notice to the state to respond to it. Your name is?
V. Siri, Lordship. V. Siri.
Please write it down. I may make a mistake. V is a Sirie, S-I-R-I-E.
Lordship.
Okay, Mr. V Sirie, S-I-R-I-E. Commander and Counsel for the petitioner. Yes. Whereas, Miss, I forgot the name again.
Inahuli, Your Lordship.
Inahuli, learned government advocate appearing for the state respondents. Next paragraph.
May I please, Your Lordship? My lord, I am appearing on behalf of my senior for respondent number 5, Accountant General, Office of the Accountant.
As well as Miss.
P. Mombeni Izum on behalf of Joshua
It's
Shetty.
right down the name. So on behalf of the standing counsel for
Respondent number 5, Accountant General.
the Accountant General of the state. Next paragraph. Government advocate has submitted that pursuant to order dated 1/8/2025, passed by this court, she has obtained, she's received written communication dated 26/8/2025 from the Deputy Secretary to the Government of Nagaland, Transport Department, thereby informing that the observation of the comments conveyed by the P&AR department within bracket pension branch bracket close is as under. This copy this. Full stop. Next para. By referring to the notification dated 13/7/2025, which is filed as Annexure E to the affidavit in opposition filed by the respondent numbers 1 to 4, it is submitted that the same provides for inquiry by the Deputy Commissioner of the district. And accordingly, as the deceased mother of the petitioner hailed from Senapati district,
Lordship.
the investigation report regarding genuineness of the case for entitlement to family pension must be made from the office of the Deputy Commissioner, Senapati district in the state of Manipur. Next, it is also submitted that there's also a requirement of furnishing fresh medical certificate from the District Medical Board of Senapati district, certifying that the disability is of such nature so as to prevent the claimant from earning her livelihood. Next, accordingly, the court is inclined to adjourn the matter for 4 weeks so as to enable the petitioner to do the needful. Let a copy of this order. This is provided to him also. The Learned Government Advocate shall provide a copy of the said communication dated 26/8/2025 to the Learned Counsel for the petitioner. So as to enable the petitioner to do the needful. Next paragraph. The Learned Counsel for the petitioner has submitted that the petitioner already has a medical certificate from a competent authority, and therefore there is no legal requirement to have a fresh medical certificate. Full stop. For the time being, as there is no challenge to the said requirement, the court would not make any comment at this stage. Next paragraph. This after 4 weeks. No.